All right, baby. All right. Good morning and welcome to Uncivil Law, my friends. We are here hopefully for the end of the Canton retrial, and we are all hoping for a not guilty verdict and a quick one at that. Hopefully that will be our fate, and we will see. Of course, this morning we are going to hear the official jury charge to the jury in its completion. We will also hopefully get a copy of the new, exciting, revised jury slip. That'll be great. And also, of course, we are going to hear closing arguments, which are set to be an hour 15 per side. The jury is supposed to get the case pretty shortly. I mean, hour 15 per side is 2.5 hours. I can do math. And then the charge itself should take about 45 minutes, I would think, give or take. So that is 3 hours, 15 minutes. And, so we should be able to get this party going pretty fast. Pretty exciting. We're also going to see whether or not the jury was, let's try again. We're also going to see whether or not the defense was angling for a straight DUI charge, if that's what they were trying to do. I couldn't quite figure out exactly what they were trying to do yesterday. So that has been a suggestion that they were trying to angle for a straight DUI charge. So we'll see if we can get some clarity on that point. And then, of course, we've got jury watch, during which we will watch Larry DUI guy's version of the close that he did. And we'll also try to look up some of Judge Bev's previous rulings and other things that we might want to discuss along the way. We may also briefly discuss issues relating to the injunctions and counter injunctions relating to what's going on in LA. But that's a little off topic, obviously, so we'll deal with that maybe as possible. I skimmed the injunction from the court and was skeptical of the legal analysis in that decision. But we'll give it another look and see what we can do from there. All right, cool. Can they fill out the forms in 30 minutes? Oh yeah. I mean, it's just a checkbox. Filling out the form takes 30 seconds. Just check the box and sign the bottom of the page, baby. No problem. Just three X's and sign the bottom of the page. Easy peasy. I understood the defense trying to clarify 3 charges, separate independent charges. Well, there was that too. As a separate issue. You're right. I'm pretty sure there was discussion on that as well, but that was a separate thing. But yes, you are right. You are correct. I'm glad AJ is doing the closing after watching Larry. Well, give Larry a break. I mean, he hasn't spent the time pondering and all the things. Like if I gave a close, maybe I'll do a close. I'll just I don't know when I'm going to do it though. If I do it now, I don't want to do it until I guess I have to do it now by virtue of necessity. So let me see if I can give an impromptu closing argument for the defense. Let's see how good my improv skills are here. All right, let me give me a second to think about this, and we'll give it a shot. All right, let's give this a shot. Ladies and gentlemen of the jury, the collision with the Lexus never happened. The collision with the Lexus never happened. Over the course of the last month, you have heard evidence, both from the government and defense witnesses alike, that confirm this one simple truth. The collision with a Lexus never happened. We have discussed in detail the lack of evidence relating to this collision. For example, you heard from the state's own experts regarding data that was collected, both from the phone and the Lexus, relating to time sync that shows that the events could not have happened in the order that the state has been repeatedly trying to bamboozle you into believing. You have heard from the state's own medical examiner, clearly, unmistakably, the lack of any bruising, the lack of any ligament tearing, the lack of any broken bones. The state's own medical examiner, the person the government employs to determine the cause of death, was unable to determine the manner of death, labeling it as undetermined, not as a homicide. And indeed, the state's own medical examiner, from the stand, you heard her say that the injuries in this incident were inconsistent with a vehicle collision. That is the state's expert, not ours, who told you clearly the injuries were not consistent with a vehicle collision. You, of course, have also heard from other witnesses who testified. You heard from Trooper, whatever his name is, I can't quite remember right now, who testified that he saw the taillight of that vehicle when he went to go get it from One Meadows Lane in the early morning hours. And he saw only a small crack in the taillight, not it completely taken out. Again, the state's police officer, not ours, who said that he saw a dollar bill size piece of plastic missing from the right rear corner of the taillight. And indeed, we saw imagery of that car being loaded onto the tow truck, in which it is clearly depicted that only that small piece was missing, not the complete taillight blowout that the government has misrepresented. This state trooper, trained Massachusetts state trooper, trained in the skills of observation, clearly, unmistakably described this taillight as only a small piece missing. It simply does not reflect the government's case, and it is emblematic of the fact that the Lexus collision never happened. Ladies and gentlemen of the jury, you have also heard from defense witnesses, including several notable medical experts. You heard from multiple experts trained in their field about how they did not find evidence of a collision. You heard from one medical expert who is a former police officer herself in Massachusetts, spent 7 years as a police officer before going on to become a medical doctor, and has since treated thousands of people in the emergency room, in addition to being double board certified in forensic medicine and emergency room medicine. This doctor has seen countless examples of wounds of all kinds, from gunshot wounds to stab wounds to wounds caused by blunt instruments, wounds caused by sharp instruments, wounds caused by animals, wounds caused in every possible way. In her 30 years of working in the ER, she has seen thousands and thousands of people come in with broken bones and torn ligaments and bruising, people that were injured by human beings, people that were beaten up, people that were hit by cars, people that had been beaten up or beaten by bats. And she knows and has testified as to her experience relating to wound recognition, particularly dog bite recognition, because in addition to being an ER and former police officer and double board certified in emergency medicine and forensic medicine, she also has experience specifically relating to dog bite wounds. She told you about the papers that she has written relating to dog bite wounds, the conferences that she's given lectures at, her reputation in the community of doctors for her expertise in dog bite wounds is second to none. She is exceptionally well qualified. And she testified clearly and unmistakably that these wounds were not caused by an animal. She also, or apologized, that they were caused by an animal. Wrong way around. Apologize. That they were caused by an animal. She also clearly said that these wounds were not caused by a vehicle. She has seen hundreds, thousands of vehicle accidents, some minor, some fatal. And she knows what a motor vehicle accident looks like. They happen every single day in the ER. She knows what to look for in a motor vehicle accident. And she knows and testified clearly and unmistakably, this is not a motor vehicle accident. We also heard from another doctor who was the chief medical examiner for the entire state of Rhode Island. She not only conducted thousands of autopsies herself, but supervised autopsies. She testified that in her career, she has seen 10,000 autopsies, whether she did them herself or she was a supervisor on behalf of the state for the entire state, the lead medical examiner, the go-to person for the entire state of Rhode Island. And she likewise testified about her extensive experience with her 10,000 autopsies. She knows what to look for in an autopsy. She has seen bodies that have been injured by people, stab wounds and gunshot wounds, people that have been beaten up by bats or by fists, people that have been injured accidentally on the job, that people that slipped and fell. She has seen it all. And she testified clearly and unmistakably that these wounds were caused by an animal. Based on the pattern recognition, based on the way the pattern of the marks went vertically across the arm. She testified how this could not have happened as a result of a medical accident, and she also testified about the lack of wounds, bruising, broken bones, ligaments from a vehicle collision. That those indicators are simply not present. Ladies and gentlemen of the jury, the government has attempted to bamboozle you at every stage of these proceedings. They conducted a shoddy, incomplete investigation. The lead investigator, Michael Proctor, is corrupt. We heard his text messages. Insert text messages here, like just read them, We heard him say, blah, 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 blah. Quote him for a while. We saw a complete rush to judgment. We saw an incompetent investigation. During the first search of the property and the second search of the property, no taillight pieces could be found. Even though, of course, having been snowing, everything was covered in white. Anything not white, such as a red taillight piece, will stand out against a white background. But despite the leaf blowers and the rakes brought in by the police during the first and second incident, they were unable to find any taillight pieces. When they eventually did find those taillight pieces, those locations of those pieces were not marked. We don't know where they were found. You've heard the government talk about a debris field. We have no idea what the debris field is or looked like because they did not make any record of where those pieces were found. Every chart depicting it has been simply a random speculation into the dark. We saw a complete rush to judgment. No investigation about what happened inside the house at 34 Fairview. The police didn't go in and talk to any of the witnesses during the evening in question. They didn't even bother to ask whether or not they could have a look around. Didn't even bother to ask whether they could have a look around. They weren't curious about anyone in the house or anything that might have happened in the house. With a dead body in the front yard, apparently the police had no curiosity whatsoever about what happened in the house. Wouldn't like even asking the homeowners, hey, did you see anything? Be like a pretty standard investigation tip. Wouldn't you want to, at a minimum, just ask everyone in the house, hey, by the way, didn't you happen to see anything or hear anything? Would you like to have that discussion? No, apparently we wouldn't. Apparently we don't want to do that. We don't want to have a look around and see whether or not there are any signs of a struggle, perhaps, that might indicate how this body wound up on the lawn. Any signs of a fight or other problem? No, we don't want to have any of those things. We just want to pin it on the girl. We've within 12 hours, double check my timing on that one for the actual closing argument, but 12 hours is a placeholder here. Within 12 hours, the lead investigator had been texting that, the girl was going to be the one that was going to be charged. A very quick rush to judgment based on woefully incomplete understanding of the facts. No desire to look, no desire to find. Where is Chloe? Where is the dog? Where is Chloe? Why didn't they check Chloe out? Why didn't they look into that? They just want to pin it on the girl. Ladies and gentlemen of the jury, the accumulation here proves many have many reasons to have reasonable doubt. That reasonable doubt is doubt based on reason. Between the various medical examiners and and then throw in some stuff about aperture that I can't get to because the court is now starting, so the court is interrupting me. So throw in discussion of aperture for a while and all their physics and stuff and blah 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 blah. And ladies and gentlemen, jury, reasonable doubt's been proven in spades, blah, 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 blah. So that's my impromptu closing argument. How'd I do? Did I do okay? All right. For not having thought about it at all? Okay. Hopefully I did okay. The garbage. Look at the closed caption. Look at the closed caption on screen. The closed caption says the garbage. The closed caption knows what's up.
Now opening, may be seated.
Jurors on their way?
No, we need to be heard, unfortunately.
Okay, come over to sidebar, please. The jurors are on their way.
Sidebar. Yeah. So yeah, also, ladies and gentlemen, we heard from Aperture, and we can go through their stuff, and we can go through their testing. We can do a little cross comparison between Aperture's testing and Arca's testing. Throw in some allusions to the blue paint, in there. So we talk about Aperture for a while, do a little cross comparison for a while, and then we'll get into reasonable doubt. We'll talk about what reasonable doubt is. Then we'll just enumerate, reasonable doubt is doubts based on reason. That's what a reasonable doubt is. If you have any doubt based on reason, you must acquit. If you have a doubt based on reason, you must acquit. And then I'll just enumerate all the reasonable doubts. I'll just go through them one by one and enumerate them. Just list them out. Any one of these things is sufficient. It is the state's burden to prove the case beyond a reasonable doubt. I might even go so far as to explicitly make the point that I make sometimes on chat. I might even go that far in this kind of case. I might even say, it is not your job to try to figure out who did it. This is not a whoudonit. It is not your job to figure out who the real murderer is not your job even to determine whether or not Karen Read is the murderer. Your job, strictly speaking, is to determine whether or not the state has proven it beyond a reasonable doubt. That is your job. Remember your job. Reasonable doubt is manifest everywhere. Hold the state to its burden. Make the state work for their burden. Do not convict someone of murder and sentence them to prison based on half, dreamed up bullshit. And I can't use bullshit in a closing argument. I don't think that's allowed. Half dreamed up, poppycock. Blah blah blah. Quit something. I lost my flow, guys. I lost my flow. I'm sorry. I was in it. I had a nice flow. Then the court interrupted me. I've lost my flow, and I'm having a tough time getting back into it. Sorry. So you'll just have to imagine that I said all those things with the style of what I did in the first half, and go from there. But that's sort of my back of the envelope closing argument. Hope you enjoyed my TED Talk. Travis, how did I do? Did I do good? On a scale of 1 to 10, Travis, on a scale of 1 to 10, how did I do for a closing argument? Be honest. I'm sure it wasn't the best you've ever seen, but did I do okay for off the cuff improv? How did I do? Did I do all right, Travis? You can be honest. If you think it was also ran and you want to be say it was average, that's fine too. 7. I'll take 7. Yeah, 7. I'll take 7. Yeah, that's it. Yeah, it could for absolutely no polish whatsoever. Yeah, 7's not bad. You convinced me. 9.5. Excellent. Bev denied a motion for transparency regarding selection of alternative jurors. Nice. It doesn't hurt as the defense that I have a lot to work with. That always makes me sound better. See, that's also one of the things you also have to sort of. That's one of the things that you have to adjust for sometimes, and that can be really, really tricky, even for professionals. Like when you're rating the quality of the lawyer, you have to remember the lawyer is stuck with the case they're dealt. Now, that is less true in the case of the prosecution, because the prosecution has the choice to not bring the case. So that is less a factor with the prosecution. But you have to remember the quality of the lawyer is distinct and apart from the quality of the case, right? So if you have a lawyer with a completely shit case, right? The lawyer doing a good job doesn't necessarily mean that they convince you or they win, right? Just because the lawyer can't convince you and just because they can't win doesn't mean that the lawyer isn't doing an exceptional job. Because sometimes your case is shit. And we can only do so much. We're human beings. There are limits. There are limits to our powers. So that is one of the challenging things to adjust for, is to remember, and also incidentally, by the way, why putting aside, let me try to phrase this carefully. There are many things about Brennan that make him a good lawyer. There are ethics issues that are problematic, especially when he's in the governmental role, right? So as the prosecutor, there are ethics issues. Let's put aside the ethics issues for the moment. Lord have mercy. Let's put aside the ethics issues for the moment. But he is a good lawyer in many, many respects. He in other respects less so. But there are things about Brennan that are very good. Yeah. There are things about Brennan that are even admirable. But then again, yeah. There are commonwealths and there are republics. Look, even the Commonwealth states sometimes call themselves state. Okay? Even they call themselves state sometimes. So you can't expect me to get it right when they can't even always be bothered. Okay? Lying about evidence is admirable. Okay. We have to be careful here. When we say lie. You have to be careful here. Putting aside the issue relating to the sweater or putting aside the issue relating to the hoodie, because putting aside that issue. Lawyers. I don't even know if I want to make this point with respect to Brennan. I don't even know if I want to make this point. I mean, it's true. It's just like when I'm saying it with respect to Brennan, it just makes me feel dirty. It's like I don't even know if I want to make this point. Lawyers shade without necessarily lying. Like what lawyers do is they elevate evidence one of the things they do. One of the things lawyers do is they elevate evidence that's good for them and they diminish evidence that's bad for them, right? So a lawyer will obviously present the best possible evidence for their side, because of course they will, because I'm going to take from the pool of evidence and use all the evidence that makes my side look as good as I can. So that's one thing. And then also I'm going to do whatever I can to try to make any evidence that's unfavorable disappear or diminish it or otherwise make it like less important, right? So, and one of the ways I can do that is by characterizing evidence or by coloring evidence without overtly lying. There's shades over here. It can get complicated. Now, as a prosecutor, once again, that comes with additional ethical implications, as separate and apart from a normal lawyer. So, there's that issue. But yeah, that's okay. Yeah. A defense filed a motion for transparency, denied. Yeah. Relating to transparency. I don't know what the motion exactly is in terms of how the alternates are collected. I liked Judge from the Rittenhouse trial where he just had the tumbler. I thought that was cute. And then he had the defense pick out from the tumbler themselves. I thought that was also pretty cute. Like, I'd never seen that before, but I thought it was pretty cool. Break out the tumbler, baby. Break out the tumbler. There's a blue man with a blow-up dummy across from the courthouse. Excellent. Yeah. However, Brennan did somewhat overextend a lot. Now, so he pushed the boundaries of ethics at multiple times, and you also have to be careful as a lawyer on pushing that sometimes, because credibility is a major factor in front of the jury. And so if you really like, you have to be careful with your shading, because if you go too far, you can lose reputation, and that, is a big problem. So you do have to somewhat moderate it. You can't quite go to the nth degree. And Brennan goes to the nth degree. Yeah. And especially by the end of the trial, it became very annoying. I held on for as long as I could, but I've lost the will to live. If I 100% know the defendant is innocent, well, first of all, they wouldn't 100% know unless they were there. But can you still serve as a prosecutor? Well, no, not really. The prosecutor has to believe that the defendant is in fact guilty. If they don't believe it, they can't bring the case. So, yeah. Can I reenact the final scene from Al Pacino in Justice for All? I'd have to look up the script, but maybe. Thank you for the super chat. Yeah, the cross of Lenschler stepped over the line. Yeah, if it wasn't already apparent, I agree. Yeah, he definitely stepped over the line. Yeah. The ethics issues are real in this case for the prosecution. The ethics issues are very real. As has been said multiple times, prosecutors have a duty to seek justice, not just convictions. Yeah. And of course, the Commonwealth also represents the defendant, at least a little bit, because the defendant is part of the Commonwealth, last I checked. So, the prosecution is supposed to protect like the fundamental interests of the defendant, because they're the government. So they actually have duties to the defendant. As the prosecution, right? So their client is in some sense, I suppose, their client includes at least partially the defendant, a little bit. I mean, that's one way of thinking about it. I mean, they have duties to them. What else could it be, right? So, I mean, there's that. Yeah. Will the same lawyers defend her in the criminal civil case? Almost certainly not. Most lawyers don't do both. Who will? No clue. Yeah. These lawyers specialize. Yeah, most lawyers specialize. There aren't a lot of what they call street lawyers anymore that do kind of everything. There are some, but there aren't a lot of them. I want to be a street federal appellate lawyer. That's what I want to be. I want to be a street federal appellate lawyer. Is it a federal civil case? A street federal civil appellate lawyer. There you go. What cases will you take? Is it a civil case in the federal system? I will take your appeal. I'll do all the federal civil appeals, all of them. All the federal civil appeals. So I'll be a federal civil appellate street lawyer. By the way, in case it isn't obvious why they call them a street lawyer, in case it isn't obvious, it's because they'll take any case that walks in off the street. That's why they call it a street lawyer. See, because it. Okay. Curtis for the streets. Yeah, I guess that's one way of putting it. Thanks. Like an ambulance chaser? Well, something like that. Yeah, well, I'm not sure what the problem in transparency is. What's the problem with Like, what's the problem? You know what actually a reasonable way of doing this would be like just use like random.org or something. You know, use random.org and generate like, you know, list and have them pick one. That could be good. That would work. Yeah, like, all right, counsel, I this morning I went to random.org and I had it create 10 lists of random order. Pick one of these, pick one of them, and that's the order that it'll do. So yeah, something like that could work. Didn't the UI guy say our civil case lawyer had been in court every day? I think that's what he said, yes. Which means he's getting paid. So that's costing a fortune. I pictured a lawyer walking the street and asking if anyone needed a lawyer. That would be one way of doing it. Yeah, they have a Tumblr, but it's done in a back room. That's not ideal, man. Just do it in the open. What's the problem? Just do it in the open, you know? What if you did it with the lawyers making the picks? That'd be interesting. What if you did it that way? That'd be really interesting. What if you need to eliminate 6 jurors and you did it by asking counsel which of the jurors they want to eliminate? Like, we'll do it like pick 'em basketball. Can you do that legally? Is that legal? Probably not. I don't know if it's ever been done before. Is that legal? Maybe we'll look that up during a break. Yeah, it's like it will just go in order, and you pick which jurors you don't want. Yeah, is that legal? Probably not. I don't know. That's interesting. Someone's got to have done it somewhere, right? Some court has got to have done it somewhere. There's got to be a case on it somewhere, right? Surely someone has done it. 3 picks each. Yeah, exactly. Right. 3 picks each. And you just go and you just alternate, right? Prosecutor, which one do you want to eliminate? Okay, defense, which one do you want to eliminate? You just go in order. Yeah. Yeah, do it that way. Can you do it that way? That'd be good. The jury draft? Yeah. Yeah. Is that ethical? Is that legal? Maybe we'll try to do some case law research and figure out if that's ever been done before. If I ever become a judge, maybe I can be the first one that's ever done it. Then I can be an appeal case someday. Exciting. Someone's got to make new law. It might as well be me. Yeah. That's definitely a good trial judge. That's definitely a good trial judge. How can I do things so that I will be an appeal case someday? That's definitely what you want out of your trial judge. How can I be a cautionary tale to others? Lord have mercy. If I can get away with chess clock in a criminal case, though, I'm doing it, though. I swear to God. If I can get away with it, I am going to make chess clock a thing personally. If I ever become a judge, I am going to do my best to make chess clock a thing. Chess clock is the greatest thing ever. You get 40 hours each, figure it out. Then, probably the Supreme Court of Texas is going to tell me I can't do that. Man, Supreme Court of Texas, you can't do chess clock, Kurt. You can't do chess clock. Yeah. Well, who do you think you are? Hey, we're the Supreme Court of Texas. Hey. Well, actually, no, it would be a criminal case, so it wouldn't be the Supreme Court of Texas. It would be the Court of Criminal Appeals of Texas. Never mind, because we have two Supreme Courts for some reason. Yeah. It'd be it would be the Supreme Court, it'd be the Court of Criminal Appeals. Yeah, Johnny Depp absolutely had chess clock, 100%. Yeah, we're talking about bringing it into a criminal case. That's also something we'll look up during the break, because I'm pretty sure it was done, and I'm pretty sure a Court of Appeals said there was a problem with it once. So we're gonna see if we can find that case during the break, and we'll look up the magic of chess clock in criminal cases. I may need Travis to help me round up some members of the bar to sponsor this plan. I may need some help. Oh, by the way, would you guys do me a favor? Judge Bev apparently has been overturned in something like 6 cases. If you guys in chat want to do something helpful while we're waiting, could you help me look for those cases? Because I'd like to review them during the break. So if you could find the cases in which Judge Bev has been overruled in any case, I think that might be interesting. So if you could help me find those, and if you do find them, please put them in the Discord so that they'll be available. I'd appreciate it.
You are unmuted.
Julie, can you set this up?
Thank you.
Plug it in for me. I need to see that flash drive.
Now open your
Here, I
seat.
need my mouse too.
Six, it seems like a lot.
All right, so why don't I see counsel over here at sidebar? I've got my computer up.
I don't know whether 6 is a lot or not. Depends on the number of cases. Like, you'd have to do it in terms of like percentages. Right. So like, is 6 a lot? I don't know. Out of how many cases? And also what is the norm in the jurisdiction? Yeah. So you'd have to like, do that accordingly. Yeah. So if you could help me find those cases and post them in Discord, that'd be very helpful. So we can review them as we're doing a little jury watch. Yeah, I've heard they've been overturned because they're too favorable defense too. So it'd be interesting to review them and see what is going on. Good morning to the 545 of you who are currently here and spending some time with me. I appreciate you guys being here as always. You make it worthwhile for the most part, although I'm not going to lie, I'm a little tired. I'm ready for this to be over now. These take a lot out of you, especially when you're solo. Takes a lot out of you. I'm ready for this to be over. Miss Shorty is here. Good morning, Miss Shorty. Would you like to join me on screen? I'll send you a link just in case anyway. Send some links out this morning. All right, Miss Shorty, here's the link for you in your X. And Travis, I'll drop you the link too. What am I trying to do? I'm trying to send a message to Travis. All right, cool. I'll send it to Lawfaria too if she wants to drop on. If you want to drop on for verdict watch. Send her that link. Great. Who else do I need to send links to? Microdots. All right. Let's see. Who else can we send it to? Ooh, is Aiden available? He might be. All right. Oh. Send one to Bettero in case he wants to drop by. Send out all the DMs. Many DMs. Send one to Pop Brothers at Law. Still trying to get those guys on. It is Friday. In fact, it's Friday the 13th at that, which is, I don't know what that means about anything. But if this case starts on April 1st and ends on Friday the 13th, there's something in there somewhere. Yeah. So, yeah, that's a thing. He's live at the courthouse. Well, in case he wants to do something else, I guess. He can always join me from the courthouse. He can always just pop on stream from the courthouse. That'd be fine by me. I'll send one to him as well, too. I'll send one to Lori, just in case. I also send one to Nate the lawyer because we haven't heard from him in a while. Where's Nate's messages? I have too many DMs with too many people. That's my problem. All right, so send out some DMs, send out some messages to people. We'll see. I sent to Larry, I think. No, I didn't. Should we send one to Larry? Yeah. Why not? Oh, Nate's in Disney World. That's right. I forgot. Nate is on vacation, so unlikely to join us. That's disappointing. Emily Baker. I don't really have any method to contact her, unfortunately. I don't have DMs with her. I could send one to her email, but she's got her own stream. Yeah, she's not going to hop on my stream. Rob from Lawn Lumber? No. Melanie, she's doing her own stream too. She wouldn't hop on my stream. She's doing her own stream. Andrea, again, doing her own stream. She's not going to jump on my stream. That doesn't make any sense. They're not going to give up their own stream to jump on my stream. That doesn't make any sense. You can't find any of the cases that Bev was overturned on appeal? Rakita, absolutely not. I will not stream with him ever at this point. I will not appear on a stream with Rakita. Yeah, Emily D. Baker has 30,000 live viewers. I know. I don't know what she's doing that I'm not, but yeah, no. Andrea had like 7,000 before the stream started this morning. Melanie's been hitting 15,000. Emily has like 30,000. So it's like, I don't know what they're doing that I'm not doing. They're all women. I'm not sure how much that plays into it, but I'm not 100% sure what they're doing. It can't be that I'm mean to chat. I mean, like Emily, has even a stronger lockdown on chat than I do. And she gets a lot of people. So it's not because she like moderates, because she moderates the hell out of everything. So yeah, I don't know what it is. YouTube is boosting women, maybe. That could be partially. Danny and direct, maybe. Yeah, let's I'll send a note to Danny and see if she wants to jump on. Let's send a note to Danny. Do I have a message just for Danny? I don't have DMs for Danny. Also, she appears to be streaming, so yeah, she's live. So she's streaming, so she won't join my stream. So Danny Ann is out. Wish the trial video was full screen as opposed to me? You don't want me to be on screen at all? I mean, I could put myself down in the corner like this, but that makes me very, very small. Is this better with me down in the corner? Is this what gets all the views? Me being like relegated to the corner like that? I could also do this, but I like this even less. Wish the trial video was full screen as opposed to me. You got to do something about the audio feedback, Travis. Thank you. Yeah. No. 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 Okay, this one, I guess. How are you doing this morning, Travis?
Wonderful, Kurt. How are you?
Excellent. Feeling good.
I'm a bit confused, but I think everything will get clarified when they start going through the stuff. The two key things for me that I really want to see is the verdict slips, and then if there really is going to be a lesser included offense for misdemeanor DWI. I just can't imagine that, but
yeah,
maybe so. I don't know. Massachusetts has got some quirks that we've both discovered during the course of this. That they're just baffling. But yeah, I'm still perplexed. If the defense asked for the lesser included offenses that were in the first trial, all of those are very, very serious felonies. And
yeah, I don't understand. I don't get it. I understand why you might do it in some situations. I don't understand why you do it in this situation. I don't get it.
Mark Biederow was of the same opinion.
Like
was-
if you had a different kind of murder case, and you
Yeah,
feel
absolutely.
and you think you could sell them on manslaughter, like, so it's like, like, I don't think I can sell them on, my client didn't do it, but I think maybe I can sell them on if this is only manslaughter. So it's like, I want the lesser included manslaughter, so I'm going to try to sell them on manslaughter as the defense lawyer. That's my strategy. Like, I can see that in a case, and we kind of saw that recently with that doctor who murdered his wife and left her in a lake, right? That's basically what it boiled down to, and the jury did in fact convict of manslaughter. So that was the strategy, and it worked. So that does make sense in some situation. I just don't know why it makes sense in this situation. I don't get it.
Me either. So with police officers, they're typically charged with manslaughter 2 to 20. And then the big dilemma is whether the defense should request a criminally negligent homicide, which is state jail felony normally, but with a firearm, it's 2 to 10. I mean, do you ask for that? That was in the Amber Geiger case up in Dallas. She went on the wrong floor of her apartment complex, and that case. I agree with you. I'm just not seeing it in a case like this. Now, if they got a misdemeanor DWI lesser included, yeah, I could see that, but not the felonies that were involved last time, which were involuntary manslaughter, intoxication manslaughter, and intoxication either over an 08 or just by the sounds like they're starting. So let's see.
Yeah, I don't believe it till I see it, Travis.
Yeah.
All right.
So I'm pulling up your cases right now, and I'm here if you need me.
Cool. Yeah, someone posted a link to Andrea's Substack in the Discord, which they say has a link to the cases that Judge Bev was overruled on. So we can take a look at that we'll take a look at that obviously once the jury is charged. So, or during lunch break, whichever happens first, I suppose. And we'll take a look from that. Back to the Spinny fan. Spinny fan, what do you think? Guilty or not guilty? Guilty or not guilty? Who the justice wonders, should your fate abate?
Yeah, so I've learned I don't trust anything in terms of cases posted by anyone. I mean, if Andrea did it,
Andrea's smart. She's incredibly good.
If Andrea did it,
Andrea's good.
Yeah, but this chat GBT thing, which I don't use, but man, the stuff I'm seeing, that it makes up cases and a citation, and people are getting hauled before various tribunals about using cases. Williamson County, which is where I'm at, coincidentally enough, you have to sign.
I lived in Cedar Park before I moved here, so
Yeah, we had to sign an affirmation if you use chat GPT. If you use the AI, you have to do an affirmative certificate that you check each and every case, because they were getting so much crap, just bogus citations. But
shouldn't you check each and every case anyway? Isn't that sort of one of the fundamental roles of a lawyer?
Well,
to actually check your case for if no other reason, to make sure it actually says what you're going to say it says. That would be nice.
Well, that's what I was taught in law school, but maybe things have changed with tech. I don't know. So many things have changed with tech. I'm a dinosaur. Fax machines came out during my practice, and have some funny stories about fax machines. Cell phones came out during my career. So, the light bulb was there.
Did you have one of the Motorola StarTACs? They were cool. I missed those.
I had a StarTAC, but
yeah, they were cool.
But I had the brick, and then I had
the brick.
I had the slimline brick, and then but StarTAC, I loved them. Oh man,
that was a cool phone.
Yeah,
that's where it was at. Everything's downhill since then.
I even had the calendar app that went on the back of the StarTAC, and they integrated, and oh man, I just loved it.
Yeah, so much for starting at 9 o'clock. Yeah, we're going to start exactly at 9. I want this jury here. I'm going to start at 9 on the dot. It wasn't meant to be. It wasn't meant to be. Apparently they are not about selecting the alternates in open court in some manner. They apparently, let's pull them from the hopper in front of everyone is too much for this court. We're going to do it in the back room. It's going to be fine. Okay. Sure. That's great. I want to do it with dice. That'd be good. I'm going to roll D20. I'm going to roll D20 until I get the, yeah, I like that. Actually, that's actually the way I do it in court, just because that sounds like fun. Yeah, I'm going to get a D20, and whatever number comes up, that's the juror that gets kicked off. And we'll just keep rolling until I get 6 jurors off. Excellent. Yeah, that's how I'm going to do it in my courtroom. D20, baby. D20 for the win.
So speaking of tech, you enlightened me on something I never knew existed. This you could buy shares, essentially betting on the outcome of a trial.
Oh yeah, this is kind of new though, so there's no reason that you should know. That's relatively a new thing.
And man, oh man, philosophically, it just caused me a lot of problems. But somebody gave me the link.
If you're the lawyer in the case, what are the ethics of betting on your own case? How's that ethically?
Oh man, well, I guess you'd never go to the Hall of Fame. The Texas Criminal Defense Lawyers Hall of Fame. You'd be banned from that. Yeah, it's just mind blowing. But
incidentally, what is Polymarket doing this morning? Is a good question. Let's take a look and see what they're doing today. Polymarket, what are you doing today in the stupid? 26% chance Polymarket is saying for conviction at the moment, and for acquittal, because they're running it as separate polls for some reason, which then leads to the possibility of there being more than 100%, which is great. 63% to acquit. So there you go. 26% to convict and 63% to acquit. So 99%. I guess that adds up to, which leaves an implied 1% hung, I suppose.
That's a massive change from yesterday, right? It's like the Kentucky Derby. Right before post time, wasn't it about 20% at one time for guilty?
Oh yeah, I mean it was up at like 60% basically at one point. Yeah, it's been like up and down. That's count 1 or count 2, incidentally, for guilty, the way that the bet is written. So neither one explicitly accounts for only a conviction on count 3, which is funny. So yeah, I guess it's 1% for applied 1% conviction on count 3 or hung is what the implied is.
Yeah, so a couple of just really strange.
It's 89%, 26 plus 63. You're right. It is, yeah, 26 plus, yeah, that's 89, not 99. Yeah, sorry. My math, I didn't math correctly. I am ashamed.
You went to the same course of instruction Brennan did for math?
Yeah.
So Massachusetts, I think it's discretionary, but the court can select the foreman. Never seen anything like that.
Yeah. And apparently, I'm not 100% sure, but it sounds like they take that person out of the hopper, which makes sense, because why would you select the jury 4% in advance and then put them in the hopper, and then if they get drawn, then you have to select a new 4-person. That doesn't make any sense. So you get to like force somebody onto the jury. That's like, what the fuck? How's that fair?
Yeah, that's mind-boggling. And then You take the 12 plus all of the alternates, which is 6 in this case, total of 18, and then the clerk draws 12 out of a hopper. But instead of doing it right there in the courtroom in front of everybody,
I know, right?
they go to a back room and the clerk draws it out with nobody there to see. But even if they did it in the courtroom, I've never seen anything like that either. Now, we have alternates, but they're not told they're alternates. And then they're not told until the very end so that they pay close attention.
I don't think I really very much disfavor the alternates being selected by anyone in advance. I don't think the alternates. I don't think there's any point, and it doesn't make any sense. You should not worry about that until the end. That's my view. So I really dislike them saying, "Oh, these are we know they're alternates from the get-go." I'm like, that sounds like some absolute bullshit to me. What's the point of that? I don't get it. Like, why do that? It doesn't make any sense. Just select your jury, select your 18 people, and then, let it be random at the end. What the fuck? That way no one knows. Even the lawyers don't know, which means that they won't treat anyone differently. The court won't treat anyone differently. They'll treat everyone the same because they have no idea.
Yeah, I think the reason why it's done in Texas and in most states is you want to focus your peremptories and your challenges for cause on that 12. You want to focus on that. The math works out because the way jury selection works, depending on certain things whether you're even going to reach those 2 back rows. Because if you take 12, let's say each side gets 6 peremptories, that's another 12. So the target zone's 24. And then depending on who gets excused by the judge for whatever reason.
How about no preemptories? That's actually an interesting idea. We'll just have no preemptories. 4 calls only. Right. I'm look, this is supposed to be a group of reasonable people. Reasonable people may not necessarily be your favorite people, but that's just your shit luck. Maybe. How about that?
Well, but so take a case like this, and then the challenge for cause on pretrial publicity is that you can't challenge them for cause just because they followed the case. The only way you can challenge them for cause, at least in Texas, is if they've formed an opinion based on what they've seen. And you get somebody waffling on there.
Any chance of negotiating a deal? Not a chance in this world. There's not any chance on the face of this earth they're trying to get a plea deal. No. They might be negotiating over like lesser included or something, but not on a deal. Yeah, but the idea of peremptory challenges, the law review articles have been written on that. I've read a law review article before that basically said, how about no peremptories? It's like, yeah, that's an interesting proposal. Like, yeah. How's it going? If we're starting at 9, it's not going great. Yeah, Travis is hiding Chloe. Yeah. Do you have Chloe? Is that where Chloe's been? If so, can I visit Chloe? I will give it treats.
I can't recall. She's flown off into outer space.
That's a problem. Dogs have gone to space before, Travis, so
Well, one, but let's see. The Russians sent up a dog, and then nobody knows what was her name. Sitka. She died in outer space. Sadly, they don't tell you that part. Now we sent a chimpanzee, not a monkey, a chimpanzee, and brought that back alive. So there has been a dog in space. So we don't need to send another one. But no, in real life voir dire, you get these folks who are just waffling. They're equivocal about, can you look at my client there at counsel table and in your heart of hearts see him as not guilty? And well, I can try. And then depending on how close you are to busting the panel, judges get more and more open-minded about who can stay on. And you got to have those preemptories for people you're just unsure about, that won't give you a solid answer. And then every once in a while, more often than you'd like, you get somebody maybe just doesn't understand the concept of presumption of innocence, or what beyond a reasonable doubt is, like you've been talking about the last few days.
Yeah.
It
shouldn't be that hard, but apparently.
Yeah. So yeah, I'd be dead set against preemptories, because it just can really kill you.
Fair. That's a fair point. There's court noises. Will we be starting yet now, or is it another sidebar? Are we all going to go to get margaritas? What are we doing? Do you think there's a bar that's serving margaritas at 9:47 in the morning in Massachusetts?
Not margaritas, but they are serving right now. They open at 7 there.
Excellent.
So,
all persons have any business before the Honorable.
Get myself a mimosa.
Justice of the Norfolk Superior Court and for the country before. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors.
Good morning, jurors.
So I have started far too many more.
Have you ever seen a judge be this condescending and patronizing to the jury? Good morning, jury. I know it's is this working for anybody?
By saying to you folks, I apologize for the inconvenience having you wait around so long. I appreciate your patience. I didn't want to do that today,
Shut your face, Judge. Stop talking.
Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. So I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes.
The sooner I don't have to hear from Judge Bev anymore and hear her voice, the happier I'm going to be.
Research or investigation into this.
I don't want to hear your voice anymore. I don't like you.
Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer,
oh my God,
I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing arguments. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. All right, the burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Mr. Jackson?
Get my stopwatch out for this.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom.
Yep, good job.
In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent.
You tell them.
And prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice.
Nice.
In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty.
That's right, damn. That's right. You tell them.
It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable.
Yeah.
The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grille. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor in his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John. A gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learn through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here?
Good question.
In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert,
Yep.
Dr. Irini Scortibello, the
Yep,
Commonwealth's
absolutely.
medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car.
Yep.
Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question: you did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer: no, I did not. She told you, quote, I did not see any evidence of an impact site,
There you go, baby.
end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project.
Yeah.
He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory.
Good question.
But don't believe your lying eyes. The taillight's completely lit up. That would be impossible.
Yeah.
Dr. Andrew Rinchler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
Nice.
Which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions.
Only 3?
How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens.
Yep.
That's out of
Anybody
his
know
mouth.
What time you started?
Not mine.
Hold on.
The Commonwealth also used the same company, Aperture, to try to establish a time of a collision
25
that
minutes
never
ago.
occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess.
Enter Shannon Burgess.
Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to
Yep.
answer that question. That was a shame.
Lol.
Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witness Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi? Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. La Posada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth La Posada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be?
Good question.
This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks, what Proctor's probably thinking at the time. Quote, "I assume you guys are out to make it cut and dry since it involves cops. Something stinks." And Proctor responds, "Yeah," to the something stinks. And then he goes on, "But there will be some serious charges brought on the girl." Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation. Nothing. Save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. Mm-hmm. The lead investigator in a murder trial was never called to testify. Think about that. That should...
Yeah. What?
Nothing. Here it comes. Here's the missing witness and what you can argue, but we're going to see how close he gets to the line.
Okay. 41 minutes in, by the way, for those who are keeping track at home. So we've got another 35 minutes to go. So let's see how it goes.
Stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer, smooth part of the housing. Not any shard, it was the outer, smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds.
The little hair that could, baby.
But that little magic hair just clung there.
Yeah.
Just hung on.
Yeah, I'm here. I'm in
That
for it.
same
Let's
hair
go.
that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it.
Yep.
Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one Not Michael Proctor or anybody else checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat.
Yes, the track the cat and mouse snow.
There was no body.
That's a scientific term now, apparently.
Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth hasn't presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk, she wasn't stumbling, she wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe, grudgingly, had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty, because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet?
Mm-hmm.
Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, Haas Long to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses. Lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was, in real time, she was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession, it was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed, or anybody in that position, might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video, multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered, he's bleeding, his eyelid is cut, his nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moment, that Higgins would be in that Sallyport, that the 42 minutes of the Sally Port video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office. The same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics, has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know, I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it.
He's going to get cut off pretty soon.
And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Read. The truth is, Karen Read is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Read because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, Let your voice be heard, not in whispers, but in truth. Let the community feel, through your verdict, that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
124. 9 minutes over. Oh God, Brennan's giving a closing. Oh God, help me. Help me, send in support, send in moral support. I needed an emergency support pup or something. Is there a rent a pup service that I can call? Holy shit. No. Okay.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard, she made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the Waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, a counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk.
You said that already. I remember. It was 5 seconds ago. My memory isn't that bad.
Night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord.
It's only been 5
It
minutes,
was
guys.
fighting. It was
It's
aggravation.
only been
And when
5
they got
minutes.
back,
Please help me.
the discontent
Please
was
help
palpable.
uncivil.
Miss Reed reaches out to Brian
Help.
Higgins, text messaging.
Help.
John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end.
I wonder if I can get champagne and orange
fast
juice
forward
delivered at
that
10 in the
night,
morning.
After this discord,
find out.
after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the Waterfall, a shot, a mixed drink. Now, it was brought up the Waterfall that there was some type of discord
if I
between
do
Brian
this,
Higgins and John O'Keefe.
if I do
They knew each
this,
other. They were
I'm going to
friends.
be
Brian
wasted
Higgins'
by the end of the
conduct
stream.
Speaking to
I
Karen Reed
probably shouldn't do
is not
this.
honorable. It's not. But they were friendly. There was no
I'm going to try to
adversarial
resist.
relationship. There was no anger between them. What we heard is they
gonna
barely
try to resist.
greeted each other. Could we have slide one, please? At the Waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins. Barely greeting each other.
I'm just going to go ahead and put a couple
Reality
items in my cart just in
sometimes
case.
is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis,
What mixer should I use for my
almost 2 to
mimosas?
3 times the legal limit.
Should I get
Almost 2 to 3
orange juice or
times
should I
the
do
legal
something
limit.
else?
Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home.
Grapefruit
No
juice,
evidence,
maybe?
mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Pineapple?
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet, the roads were very quiet, you can see it on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow, and I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
Thank you. Do you think she drank when she got home? When they leave the Waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboard to grab
orange.
a glass.
Ooh.
From the Waterfall, you see
Blood orange.
him
That's
with
actually a good call.
a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV.
Unupdated is
But
one
what
way of
he
putting
did
it.
is he found a key, critical piece of this case that did not exist before. He found it recently, and it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the Waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship, and then there's a trigger. There is a trigger on the way because they're lost, and when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the outlets. In fact, when Jen was navigating John to the outlets when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climbed, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you could move down, please, Ms. Gomez. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. There's a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly, perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Mr. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves to 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves to 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data, 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing, it could be a straight line, it could be shaking the phone.
It could
We
be.
don't know.
We don't know.
We
It could be. That's
everything.
good for the
We don't know
prosecutor's
every
side.
little detail and
That's
every little
definitely
second.
what that's
We don't
definitely
have
what you
to.
want to hear
That's
from the
not doubt. That's
prosecutor. It
not
could be.
reasonable
That's
doubt.
great. Thanks.
We know for that 20 seconds he's moving, and in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message, and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannone will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove, and what we have proven from the evidence in this case of second-degree murder, is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him.
It is murder, crockpot broccoli. Under the definition we went through it. It is murder under the definition.
Accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong?
No, he's describing second-degree murder. We went through the charge.
And if there's no doubt in your mind that she
No, it's
intended to
murder.
hit that
Second degree.
accelerator
I'll keep saying it.
in reverse, and if that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy.
The intent is to perform the act.
If somebody,
As he said, that's the
someone
intent
young,
under his
impulsive,
theory.
is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off. They're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands on the car, and there's somebody, passenger, anybody.
He does
in that
need to
car,
prove there's a collision. He does
and
need to
it
prove
then
that.
goes through the roof and kills the person in the car. Did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take
I'm not
a
sure how-
boulder and throw it off a
I'm not sure
bridge,
how Boulder got into
there's
this,
a
but
plain and strong likelihood.
He's using you're
Okay.
driving into a crowd, but a little differently.
When Karen Reed,
yeah.
in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him,
Yep.
and he died. I suggest to you that is second-degree murder.
It would be if you can prove all those things.
The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless.
Yep.
And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene knowingly,
Right.
causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that you drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested to Dr. Welcher when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving. Forever. Forever. Next slide 6, please. You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash test dummies. You know what else they do? Tech stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Ms. Reed hits John O'Keefe, collides with John O'Keefe, we don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person
If you
was
can't
hit, how fast the
replicate
person
it,
was going. But you
what
know
is the point
happened
of the
because when you look
test?
at the
How is it
debris field,
legally
when the light
relevant?
is broken. It's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12:31:56. 12:32:04 to 12:32:12 is the data which is adjusted when you reconcile the clocks on the Lexus. 12:32:09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12:32:16 is his last steps. Mr. DeSorgo says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. If we could have slide 10, please. Can you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car.
What?
Now, as John O'Keefe sadly lays on the ground, abandoned, you're gonna have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're gonna have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2, don't need to prove it for OUI manslaughter, but for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness, there was a guide, and that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone, and I ran over his foot, and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
Yep. Those statements, I tell you what, man. Those statements, I'm telling you.
When she left,
that sucks.
And left John behind, she didn't think he was mortally wounded, but she knew she hit him. She knew she hit him.
Yeah, that's definitely one way of interpreting that. That's,
And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please.
Yep.
Can you play voicemail 1, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe went in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party, he's not wrestling with Brian Higgins, he's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data, there'd be steps. If he got into the house in 20 seconds, and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps, because this phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows where you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up,
No, she didn't mean to hit him.
call.
No, she didn't mean to hit him. Does
McCabe
not
and
mean
say,
count one
"Where's
could
John?"
disappears. It does not mean that.
She
She does
doesn't
not have to
call
intend to hit him.
Brian Higgins has his number, has been texting with him. Hey, was John at a party with you?
I'm disappointed
Did
in
you
you
see John
guys. We've
tonight?
gone through the charge several
She knows
times, and you're still not
exactly
getting it
where she is,
right.
And she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house?
Please,
What
I'm not
happened
that
last
stupid.
night?
You don't understand
No.
the charge.
She calls and says, I left him at the waterfall.
Apparently.
I left him at the waterfall. See, now it's gone from panicked to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? We saw you in front of the house.
Intentional homicide, it is not. We've gone through it multiple times. It is
Hands
not
up.
that. I guess we have
Hands
to go
up.
through it again.
So then she calls someone that she doesn't know very well. She calls Carrie Roberts.
We'll go through it again when
But
we
now
get
she
to
has
the end of this
pivot,
thing.
Because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Carrie, Carrie, Carrie. John's dead. I think he got hit
It's been
by a
41
plow.
minutes.
Why do you think she chose those words? Why did she choose those words? Because she
35
knew
minutes to go.
that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that. For what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night, in a blizzard, out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight, the There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are up. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death?
What?
Kerry Roberts comes, take charge kind of person. She pulls him behind, she sees the broken taillight in Jen McCabe's driveway, and she decides she's gonna commandeer this. We're going back to Meadows, you're gonna follow me, leave the car, I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows, they obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window, they can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview, and this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you've probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him, you're gonna see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. and she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert house. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her water. He took the glass. She says it. So the Albert house, they don't need to give glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a Cellbrite record is not the same as a call detail record. There is no evidence there was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle, and then on the left, you can see where they're working. Right off the road, that's not 20 feet. That is a clip, a stumble, and a fall. And remember when John O'Keefe fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the Waterfall. And then Exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw? I asked you to take a look at that picture. We're leaving the Waterfall at 12:12, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. Could you play the clip on the left, please? 59.
So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics of getting to work 2 hours early in the middle of the blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him, she clipped him, she didn't think he was mortally wounded, she panicked, she can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him, I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him, that was earlier. Now, she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy? Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent, core people who hear her say, I hit him. I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I hit him? And I always said I hit him, but did I really say this many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Miss McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Miss McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Miss McLaughlin, the firefighter, was speaking to the defendant, Miss McCabe was next to her. Miss McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of this story was trying to help the defendant from incriminating herself. The irony. We have slide 9, please. This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the Waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down to 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the vote is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? And not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in the cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS, her hands aren't working, she's trying to type in. But what's happening during that time? It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way.
Ooh.
Oh, look at her.
Look the other way.
Look the other way.
Ooh, borrowed that
227.
phrase. Nice.
Look the other way.
Ooh.
She did. Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Albert. Maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts.
Borrowed that
herself.
phrase. Nice, John.
Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction of disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't give a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't, but that does not change. It doesn't create a conspiracy, doesn't invent a dog, it doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there was a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house, inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene.
He's in his
It's
pajamas?
near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You know, plant is already gone. You know where it is? 34 Fairview Road, on a debris field. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the Lexus go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite.
That's because you
And so
planted the
he's on
suggestion in his
stand
head.
with a new story
As you
after a
were
meeting.
dirty,
We don't
dirty,
know why.
dirty. You
But then I
you
showed him
planted
that
the suggestion in his head, you dirty asshole.
No, with it missing, and I say, is this the way it looked? It's of course before the snow melts out of the salad port so that you can see it unexposed.
Dirty.
And he says, yes, he had to agree. This taillight was gone. There's no boogeyman, there's no plant, there's no Higgins at the salad port, there's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here. She's on her profile, but she can't explain the methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time.
I don't know about
she's ever
that.
done it.
Maybe in court, but not the first time she's ever done it.
Punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. LaPosada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously there is no science to looking at an abrasion and saying where it came from. They give us no detail, they give us nothing that we should rely on, they contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision, there's no collision, there's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scorti Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car, have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions,
they're a little bit the arbiter of truth.
Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert uses Signal, an encrypted app?
What the fuck was Signal again? Unbelievable.
case.
Make it sound so
Never used it
nefarious.
before, hasn't
What
used
the
it since.
fuck?
And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic.
I believe that you
And
don't
he
know science.
flattened
I
me
believe
over and
that.
over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like...
All right, that's an hour 15. Anytime you want to wrap it up, we'll be
I
fine.
have to admit it. Now, it's funny, he
Thank
admitted
you.
it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just asking him about it. And he says, I have a sandwich and I stand in the corner until I remind him.
The ham sandwich
that we
comes
got
into it.
video footage from a documentarian, and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Strengths, it is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, what, are you going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him.
True.
But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body.
Ooh, nice way of ending. With the imagery
John
of him.
O'Keefe is not
Nice,
a
nice.
buffalo on a prairie.
Buffalo on a prairie, not so
John
much about
O'Keefe
that,
is a
but
person
I'm not sure what buffalo on a prairie has to do with anything, but okay.
by Karen Reed.
Hour 20, so slightly less than defense, I think. 2 minutes less.
Thank you. All right, jurors, the next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right, so we'll give you a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors, so 6 of you are going to be alternates. I can just tell you that. You know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is spectating. So we'll do that this afternoon. Do not discuss this case. We'll see you in about a half an hour.
All right, guys. So yeah, half hour for lunch break. So let's discuss the law again, because still, like, he's correct on the law. She doesn't have to intend to hit him. She doesn't have to intend to kill him. She doesn't have to know she hit him for second-degree murder. He is correct. He is correct. And so since we apparently still are having issues on what exactly the law is on this issue, we will cover it again. So give me a second and I will pull it up and we will discuss it again. Let's see. She never hit it. Yes, but let's just stick to what the law is for the moment, okay? And just go with that, okay? Then we can discuss the strength of the evidence. But let's just figure out what the law is for a second, because we're having problems with that. Can we just focus on what the law is for a second? That'd be great. Is it second-degree murder anywhere else? I don't know, and it's also irrelevant. Massachusetts has defined it this way, so we're going with Massachusetts' definition, because that's what matters. Okay, so it's on page 50. I thought we covered this thoroughly. Well, there are people in chat that were still getting it wrong, because there are people in chat were like, oh, he said that it wasn't intentional that she killed him. Therefore, second-degree murder's off the table. No, that's not what it means. So there are apparently some people that are still confused. So we're going to give it another go. I thought we covered it thoroughly, but apparently there's some people that are confused. So we're going to give it another go. What does he actually have to prove? All right. For second-degree murder, what does he actually have to prove? All right. So here is the elements of second-degree murder. This is from the jury instructions in Massachusetts, of course. So we are doing 2C in this. So there are two elements to this, or two major thrusts of this. There are two major thrusts. One is causality in fact, cause in fact, that the defendant caused the death of the victim. That can be a direct cause. It can also be an indirect cause. So, for example, if she had hit him and that killed him, that would be direct. If she killed him, but it didn't kill him, but it immobilized him, and due to the immobilization, he died to, for example, hypothermia, frostbite, an animal attack, a heart attack from the stress of the thing, that would be enough, right? So the cause can be direct. The hit just killed him. It can also be indirect because it is a substantial contributing factor. Because she hit him and he was immobilized, he died due to something else that was a proximate result of what she did. Okay? So that's element one. And then we're in C3, is what we're trying to show here. Okay? So as he says, it's intention to do an act. The intent here is to perform the act. The intent is not to kill. The intent is not to harm. The intent is to perform the act. Namely, in his example, it would be the intent to drive backwards, right? The intention is to drive backwards. So it wasn't a mistake. She didn't think that she was in drive, but she really was in reverse. It's not that her foot slipped on the pedal. It's that she drove in reverse because she was trying to drive in reverse. That is the intent. The intention to drive backwards. In circumstances known to the defendant, so she has to be aware of those circumstances, in which a reasonable person also would know, creates a plain and strong likelihood that death would result. So she has to know of circumstances personally that a reasonable person also would know, creates a strong likelihood of death. And as he said, like, if there were kids playing on your driveway, right, and you drove backwards towards them, most people would think that that's pretty bad because, you know, that you might run over the kids, right? So that example is an example. So like if she would know that he's in the zone of danger because she just dropped him off, right? So the theory of the case basically is, having just dropped him off, she then drove back in anger towards him. He's in the zone of danger. She doesn't have to intend to kill him. She doesn't intend to have to hit him. She doesn't even have to know she hit him. She does have to hit him. That's true. The collision has to occur. But her intent is merely to drive backwards with him in the zone of danger, and a reasonable person would know that creates a strong likelihood of death. Again, it doesn't have to be certain. It doesn't have to be a guarantee. It just poses a non-trivial risk, right? So it can't be a trivial risk of death. It has to be a strong and substantial likelihood of death. So it has to be, you know, someone can die from doing this. And I think you're there under the law. You're there under the law. So that is the theory of the case, basically. And as I've said before, confessions can go a long way. And that is still remains the prosecution's best evidence. Their best evidence is the confession, which unfortunately for Karen Reed, confessions and admissions and the perceptions of a confessions and admission can go a really long way. So Brandon started incredibly weak in his presentation, and he was weak for a lot longer than Jackson was. He was weak for a very long time. And so it's quite possible people tuned him out. But if they were paying attention, or if they were still alert in the back half, you know, he played the confessions to a T. And he played like the fact that she does have to know she hit him for the purposes of the leaving the scene of the accident. She has to know for that purpose. So he played even that pretty well. Like, so I you know, there is information, you know, from which a jury could conclude guilt. Again, like as you're trying to sort of game this out, you know, one of the things that, you know, you have to sort of do here, which is difficult. It's difficult for people to do. And it's challenging. And I understand it's challenging, but what you have to do here is you have to get out of your own perspective. And that's very challenging. To remove your own, it's difficult to remove your own perspective because in the very act of doing it, it's kind of hard not to filter it through your perspective. It's like trying to get out of your own bias. Like, even if you try to get out of your own bias, you are biased in the effort to get out of your own bias. It's kind of hard to remove yourself from the equation. But it's like you have to do your best, right? You sort of have to do your best and remind yourself that there are people who will perceive things differently than you, somewhat radically at times. They think about things very differently at times. They evaluate things very differently at times. And you have to remember that there are people who will think very differently than you and evaluate things very differently than you. You know, the easiest way to get there, you know, just like the easiest way to get there, like in a strict logic flow. Are we back already? What are we doing now? Are we back already? What's going on now in jury court? There's some commotion. Hold on a second. Okay, I think it's nothing. There was just some sort of whatever. They're still on lunch break. Okay, there's just some rustling. Okay, never mind. Yeah, the instructions will be after the lunch break. So we'll get all that. So anyways, like as I was saying, you have to sort of remove yourself and try to look at this in a more objective frame. Or perhaps a more biased frame in a different direction. Right? You have to sort of, you have to like, because you of course have your own idiosyncrasies, because of course you do. You are not a perfectly neutral evaluator. Like that's just basically impossible, right? We all have our own idiosyncrasies. What do we like? What don't we like? You know, there are things that will appeal to us and things that won't appeal to us. So like you're not perfectly objective. You might be more objective than some people, but still like, so you have to like not only like get out of your bias and put yourself into a more objective frame, which is hard enough. You have to get out of your own perspective and put yourself in a differently biased frame, which is really challenging. You have to like you have to change your own presuppositions in very radical ways or potentially radical ways, because you have to account for, you know, everybody. I mean, I know that people think very differently than you. You've met people. Some of them think very differently than you about things in very different ways that are sometimes surprising. This is not new information to you. So I'm not telling you to like, you know, believe in a unicorn. I'm just telling you to like, remember that you live in the world and you have met people and you already know this. You already know this. Some of these people think similarly to you. Some of these people think decidedly less similarly to you. So the way people think have surprised you in the way that they think because it's so weird to you. You know this already. I'm just telling you to remember what you already know, right? And it's like, okay, so some of those people will be on a jury and it's 12 random people. So like, you know, there's that, right? And so like, that's part of the equation that's at play here. The easiest way to sort of get to proof beyond a reasonable doubt in the most logical way, like, so the most analytically satisfying way to get there, at least for me, my framework, is to just believe the taillight pieces are there the whole time, right? I mean, if you believe the taillight pieces are in fact on the lawn at 34 Fairview the whole time, if you believe that, then a lot else flows, you know. And so, you know, and that is a thing you could believe. There's evidence to the contrary, but there's evidence in support of it. Namely, they found the pieces there. The fact they found the pieces there is evidence they were there the whole time. It is some evidence they were there the whole time. because they were there apparently to be found. So if you believe the taillight pieces are there the whole time, then the accident must have occurred. If the accident occurred, it must have hit John O'Keefe because nothing else has been suggested. If it did hit John O'Keefe, then you're a long way towards you have the accident. So you have like all the elements. You have the only thing you're missing potentially is now cause and fact, which is potentially a problem. But if you believe the accident happened, you can infer the requisite knowledge from the action, so that she had the knowledge that John O'Keefe was there. You can infer from the act. That's black letter law all day long, So you can infer the knowledge. Getting to that, the fact that she drove in reverse intentionally as opposed to being accident or mistake. I mean, there's really been no evidence. There's been no suggestion that she did it by accident or mistake. So if she did it, then intent is really the only thing that's present in the fact pattern. So that's sort of how you get there the most logically, or in the most analytically satisfying way, right? And then then your last barrier in an analytical frame is the cause and fact. That is the part that is the difficulty, right? So like, because that's the lowest, the most difficult ground for the government, because you have to get past there being no bruising, no torn ligaments, and no broken bones. So you have to simultaneously believe, this is challenging at best. You have to simultaneously believe the accident occurred with enough violence to create some kind of disabling injury, whatever that is, or kill him outright, I suppose, and also not leave at the same time any bruising, broken bones, or torn ligaments. So you have to believe both those things at the same time. That is challenging, but not impossible. I think, incidentally, by the way, that you're well into reasonable doubt, because although it is possible, that isn't supposed to be the standard, right? It isn't supposed to be, it could be true, right? It is, I have to believe it to be true beyond a reasonable doubt. I have to believe beyond a reasonable doubt is what I'm supposed to be doing. I'm supposed to believe beyond a reasonable doubt that the accident occurred with enough violence to create some kind of disabling injury, and yet also simultaneously not leave any broken bones, torn ligaments, or bruising, right? And I'm supposed to believe that to a reasonable doubt, because that has to be true, right? And so that is the last analytical barrier. And I don't, from the state's own medical expert, who basically are like, I didn't really see evidence of a car collision. I'm not quite sure how you're supposed to be able to do that, but maybe you just kind of gloss over that detail, depending on how diligent you are. You just hand wave that detail away, So if you hand wave it away, then obviously, well, then you're just at a conviction at that point. Or if you can somehow get there analytically without hand waving it away, although I'd love to hear that case. I'm not really sure the evidence is available to do that analytically. I'm trying to get out of myself and look at the evidence and trying to figure out what combination of evidence from a purely analytical frame I could get to beyond a reasonable doubt on that, but I'm having a tough time with that one. So even yours truly, having successfully admonished you, or having tried to admonish you to get outside your own frame, I'm apparently unable to get outside my own frame enough to find proof beyond a reasonable doubt. I'm having a tough time with that one on that element, but perhaps someone somewhere can get there somehow. What's radically out of focus? Retro detox. So I think 20% to convict is still a very sound prediction. I think 20% to convict is a sound prediction. Again, also, we could go through the elements of manslaughter if we want. But, if, especially if there are lesser includeds, which apparently the defense wants for some reason, that is beyond my understanding. But, you know, if the, especially if there are lesser includeds, it feels like you're giving them more bites at the apple and you're looking for some sort of compromise verdict. So I don't know about that. Videos going potato at times. It's Restream. Restream sometimes does not seem to have the bandwidth that I want. So I guess we have to decide whether, the only reason I really did Restream in the first place was to allow guests to come on, and that turned out to not really be a thing. Well, I mean, instead of using OBS, but OBS would have the same problem, presumably. Yeah, but we were having stream problems yesterday with Restream not getting enough bandwidth. So it's definitely a thing. I am nervous. I think that the prosecution played the admissions confessions to an absolute T. Those statements are capable of being viewed as admissions. I know some people want to pick apart the statements and be like, no, they're not admissions. She didn't admit to anything. I'm like, I think when you try to pick them apart, you're kind of missing the point a little bit, right? You're kind of missing the point a little bit when you try to pick them apart, because it's not literally just what she said, of course, that makes it an admission, right? If you think that she was just trying to be cute or something and try to well, maybe I could have hit him. Could I have hit him? It's like, if you think that's that could be viewed as, could I have hit him? Did I hit him? That could be viewed as an admission, right? It's maybe she's just trying to evade some responsibility. That could be viewed as an admission. It absolutely can be viewed as an admission. The question can be viewed as an admission. It can be viewed not that way, to be sure, but it can be viewed as an admission. So I think people who pick apart the statements and be like, those aren't admissions, that isn't what she said, I think they somewhat miss the point about how these things might be evaluated. Admission is not just what she said. Well, there's always subtext. There's always is an admission just literally the words? Not necessarily. Mm-hmm. I mean, you already know this, incidentally, by the way. You already know this to be true. So let me just point out how you already know it to be true. Can you think of any situation in your own life where you have confronted someone about something they did, and they were saying things that were evasive or saying things that were qualified, but you viewed what they said as basically being tantamount to admission? Has that ever happened to you? Have you ever been in a situation where you confront someone about something they did and their statements were evasive or qualified, but you viewed basically their evasion and qualifications as being admissions? Has that ever happened to you? I bet it has. Right? This is a situation I'm sure you've been in at some point in your life. You've already done this, right? Honey, did you cheat on me? Could I have cheated on you? Is it possible I cheated on you? How are you interpreting that statement? You tell me. You tell me. Could I have kissed him? Is it possible I kissed him? Could he have groped my ass? Could I have groped his ass? You tell me. How are you interpreting this? She didn't admit to it. She didn't say she did it. Or really? Seriously? Are you sure? I don't know, man. You interpret it as trauma. I appreciate you interpret that way. That is a valid way of interpreting it. It is perfectly valid to interpret it as trauma. I think that is the best interpretation. But how else can it be interpreted? What are the other ways it could be interpreted? Some of those people may be on your jury. So this is a valid question. Forget how you interpret it. Don't worry about how you interpret it. Ask yourself how someone else could interpret it. What are the ways it's capable of being interpreted? That is the better question, my friend. Are they trying a woman or her personality? Her personality is part of who she is. Her personality is part of her. So those are at least somewhat the same thing. Still doesn't prove a collision? Well, again, like there are other ways to get there. Like if you believe the taillight pieces were there the whole time, that proves the collision. The taillight pieces were found at 34 Fairview. If you believe they were there the entire time, that proves the collision. The taillight pieces being found is evidence of the collision. It makes the collision more likely. It is necessarily evidence. How conclusive that is to you is, a judgment, but, it's there. It's there if you want it to be. The biggest assumptions you have to make are on the cause and fact, in my view. That is the hardest thing to do from an objective lens. The easiest way to resolve this for Karen Reed is the cause and fact. That the collision simply did not lead to his death. That is the easiest way to resolve this for Karen Reed. Of course, they do have to prove each and every element, so finding the easiest element and solving it that way solves my problem, right? Because all I have to do to rule for the defense is find one element with a reasonable doubt, and I can stop thinking. That's one of the beauties of remembering. One of the beauties of remembering the question is you can make your life easier, right? All I have to do is find a reasonable doubt as to one element, and I can stop talking. I don't have to talk about any other elements because it doesn't matter anymore, right? Because that's the game. If I have a reasonable doubt as to one element, that's the game. Game over. Game over, man. Game over. So, just focus on for me, it's like, well, I don't think there's cause and fact that led to the death. So game over. I would sooner believe the collision occurred than it led to his death. Believing the collision occurred is easier. Believing it led to his death, harder in my view. Do you think they'll appeal? There's no evidence as cause of death being collision? No, they won't win on sufficiency of the evidence. I did a whole video on it yesterday. No, a sufficiency of the evidence is not a winning argument on appeal. There's legal sufficiency. If you came to me with this on appeal, I couldn't rule on legal sufficiency. I couldn't do it. And I'd like to think that I'm a relatively fair-minded person. I'd like to think I'm a relatively fair-minded individual. But if I were on the Court of Appeals, if she was convicted and you came to me with sufficiency of the evidence argument, can't do it. Can't do it. Yeah. Can't do it. Wish I could, but I can't. What grounds for appeal? Well, any number of evidentiary rulings along the way that are problematic. Bias always is a possibility to make that case. although it's challenging. But various evidentiary rulings allowing in certain evidence, not allowing certain questions to be asked. Those would be like the typical grounds. Prosecutorial misconduct. Maybe, but a lot of that has probably been cured in a legal sense. So, yeah. Prosecutorial misconduct probably doesn't work. Brady violations, but those have been cured. Yeah, various evidentiary rulings and bias is basically what comes to the top of my mind. Experts misleading about a college education? No, because that information was presented to the jury. The jury was aware of that information. So it doesn't matter. Them being certified as experts at all, however, maybe. Yeah, that might work. So them being allowed to be experts at all and testify given their bullshit credentials is a valid ground of appeal. So then, yeah, because I don't know how, I'm not sure, well, how they necessarily meet the standards for Dober, Fry, Lanigan. Although, unfortunately, I think that the courts are more lenient with Dober, Fry, Lanigan than I think they should be. So while it is a valid ground of appeal, I don't necessarily think it's necessarily a winner. I'd definitely give it a shot, but unfortunately, well, first of all, trial judges are just allowed a lot of discretion in the first place, so there's that problem. And then also the way the standards are applied, they tend to be applied a lot more loosey-goosey than I think is probably prudent. But be that as it may, yeah. Has anyone ever come prosecutorial immunity for malicious prosecution? No, I don't think so. How about the no speaking objections were handled? Maybe. If you could prove it led to some sort of prejudice. But she allowed sidebars basically all the time, so I'm not sure it necessarily led to prejudice. What the fuck is this guy talking about? He's talking about odds of conviction. He's talking about legal standards relevant to appeals. He's talking about grounds of potential appeal and likelihood. That would be the things he's talking about, vaguely. I think 20% to convict remains a good percentage point. I see no particular need to change it. What is they doing it right now? It is not 0%, I assure you. That is wish thinking. Put my money where my mouth is? What, by betting against it? I mean, I guess I could bet against it. I'd be betting against the proposition. Because if I think it's 20% likely, then I'd be betting against. So in what way are you asking me? You're asking me to bet against it? I don't understand. Yeah, if I think it's 20%, I'd be betting against. Yeah, that doesn't make sense. Polymarket's saying 22% right now. So Polymarket and me are basically on point anyway. Polymarket is basically priced correctly, in my view. That's correctly priced. It went up a percent, yeah. No bet for hung jury, not explicitly, no. There's no explicit bet for hung jury. There's one for a conviction on count 1 and 2, and there's one for an acquittal. That's 2 separate bets. But no explicit bet for hung jury. It's implied. The hung jury is implied by the bet against. Do I have a percentage possibility for mistrial? No. I haven't really thought about it, and I kind of don't want to be honest. I don't have a percentage chance for hung jury. I would think it would necessarily have to be more likely than trial 1, though. The probability, whatever it is, would have to be higher than in trial 1. Because I think there are more ways to get to guilt than there were in trial 1. There are obviously people ready to convict in trial 1. So I think, yeah. I think a hung jury has to be more probable. So, I don't know. At least 20% to hang, if not more. Will they argue again if they get a hung jury? That's up to the Commonwealth, but I'm willing to bet they will. Not for at least the reasons that they apparently have to come to verdicts on all 3 things, but I don't think that'll necessarily be the hang-up. I don't think I'm going to cover it if there's a 3rd trial. I don't think I can do a 3rd trial. Will the defense ask for a poll if hung? I'm sure they'll say something about it if there's a hung verdict. I'm sure they'll say something. I think people sometimes misunderstand me when I say things like, I think there's a 20% chance of conviction. I think people misunderstand me. I'm not sure how I can express the chant that more clearly, but they seem to confuse like me saying I think there's a 20%. I think what they think, some people think, is when I say I think there's a 20% chance of conviction, I think they say there's a 20% chance of me voting to convict, which is not the same thing. I think, or that I think it's 20% likely that she's guilty, which is also not the same thing. So I think there's misunderstanding along those lines. I'm not sure how to make that point any better, but still. It's like I said on an X post recently. It's like do people understand that if I said there's 100% chance of conviction, that doesn't mean that's what I would vote for or that what I want. Do people understand that? Because I'm not sure they do. All right. Like, yeah. I'm not sure they understand that sometimes. Yeah, I don't think I'm necessarily the biggest Free Karen Reid supporter fans. I don't think some of the Free Karen Reid supporter fans like me. I think it's part of the reason, incidentally, that I'm not getting the traffic that I would like from this stream. I think that I think my attempt to try to be more neutral has hurt me in views and clicks, which I suppose means logically I should just like basically sell out, forget what I think, and just tell the free Karen Reed people what they want to hear all the time. Judge Bev is always wrong every single time. She is just wrong every single time. Everything the defense does is absolutely brilliant in every way. Everything Hank Brennan does is wrong strategically, tactically, and ethically. I should just tell them, I just tell them those things. And then I probably get more views. Or maybe it's my personality. It could also be my personality. That's fair. It could also be my personality that they are not liking. That is a very, very fair point. Which is also a problem. It could be my personality. That's true. Maybe we need to fix my personality. I'm not sure how we're going to go about fixing that, but I'm not sure how we're going to fix my personality. That's going to be challenging at best, but maybe we can fix my personality. All right, chat. Let's fix Uncivil's personality. All right. So what does Uncivil need to do to fix his personality so that I will get more clicks and stuff? What do I need to do to fix my personality? And we'll see if we can figure out ways to do that. The makeover, I'm not sure that's going to help, but if it'll help, I'll do a makeover. That's for sure. Brighter, happier colors. I think I look good in blue, but okay, we could wear brighter colors. $20 for maximum bacon. Keep your integrity, curse. First principles are priceless. Yeah. Show more skin. I don't think that would necessarily help. I really don't. If it would help, I would wear, a push-up bra and show some cleavage, man. But I don't think that's going to do it for me, man. I don't think that's the ticket. A Runkle wig, not the worst idea I've ever heard. The cowboy hat, yeah, I wear it sometimes. I don't necessarily wear it every day. Drop more curse words. I think I drop cursey words a fair amount as it is, but we could do more. In drag? Well, love that this isn't an echo chamber. Your personality is fine. Yeah. Drink more. I don't want to drink on stream anymore. Not like I used to do. When I used to do shots for money, that was very, very bad. I don't want to do that anymore. I don't want to drink like that anymore. I learned my lesson. I don't want to do it anymore. I really don't. Although I could use a beer, and I might get a beer because I've earned it at this point. Don't call me out when I'm being an ass. I don't mind people calling me out. I just wish they would do it a little bit more respectfully. I wish they would be nice about it. Because, a honeyed word and all the rest of it goes a long way. I think my mild sense of autism, I don't agree that I have autism at all, is charming. It helps me trust your legal opinions more than your peers. Yeah, I don't agree that I have autism. And I just don't think it's true. So I don't know what to tell you. I've just been studying a subject for 20 years that I really like. I don't think there's anything wrong with liking something. And law has a lot of complexity to it. It's trying to understand it. I think it's interesting. There's a lot of things that are interesting. I don't think that makes me autistic. I don't think that's fair. Smoke a bowl, not legal in Texas. If it ever becomes legal in Texas, I may well do. Or I should move to a jurisdiction where it is legal, perhaps. Texas really should legalize marijuana. We are not on the right side of that curve. I'm analytical, but I don't think that makes me autistic just because I'm analytical. Yeah. So I don't, THC is legal in Texas. Well, to a very minimum threshold, it is like, for the bare minimum for what it is for like what is it for, hemp, basically. So THC is legal up to like 0.6%. Yeah. Do I have an unusual fascination with water? Why? If I have an unusual fascination with water, is that a diagnostic criteria that will help me with the THC thing or something? Why do you ask? Texas has revenue stamps for weed. They may well have revenue stamps for weed. That doesn't mean it's legal. It just means I have to pay taxes on it, which is true in many jurisdictions, incidentally. Yeah, the fact that Texas has revenue stamps does not mean it's legal. It does mean I have to pay taxes on it. So if I am dealing my weed, I have to make sure it has a tax stamp on it when I do. Yeah, that's 100%. LawTube is very entertainment heavy. You bring in technical stuff. Oh yeah, I think that's fair. So how do I make it more entertaining? How do I make the stream more entertaining, I guess, is a good question. I don't know. I need to figure out things I can do for like live chat goals, for super chat goals. That's what I need. Runkle has his hot sauce thing. So he'll drink hot sauce for various tiers of awards. I need to figure out something I can do that is repeatable for a goal. I'm not sure hot sauce is really for me, not for at least the reasons I don't really like spicy things. So yeah, but we need to figure out something else. They have tax stamps they'll never issue. I bet your bottom dollar they would issue them to me. I don't know what office I have to go to, but I could look it up. I bet you I could get some tax stamps for marijuana in Texas. I bet you I could. I'm not sure where I have to go. Probably a revenue office in Austin somewhere. But if I went in there and be like, I want tax stamps for pot, I bet your ass they would send them. They would sell them to me. 100%. They would sell them to me. Please no sound effects. I like the sound effects.
Aperture science.
Yeah, we'll go get some tax stamps. We'll go buy some. That'll be great. Let's find out where I can buy tax stamps while I'm waiting. Texas drug tax stamp. Okay, where do I go to buy them? Oh, apparently the drug tax stamp program was repealed in 2016. Oh. Okay. Well, apparently there are no drug tax stamps anymore. Aw. Medical THC is legal in Texas. It can be, yes. I know for a fact because I have a Texas prescription. Yes, it can be. Yes. Is there a form of marijuana that will help me lose weight? That sounds like counterindicated because weed is usually used for eating. But is there weed that will help me with the not eating? If so, I'm interested. You're still looking for the FBI clip? I got it. Hold on, where's my clip? I got it. Where is it? No, here it is.
You ask for miracles, I give you the FBI.
There you go. Excellent. So then I need a doctor who will prescribe me the weed for the weight loss in Harris County. That shouldn't be that hard, to be honest. Yeah, that should be relatively easy, I would think. We forgot about the overturned cases. We haven't forgot about it. We're just waiting for the jury instructions. I'm going to do it after the jury gets the charge, because I don't want to be interrupted as I'm doing legal analysis. So I'm just waiting. It's all online for a prescription for pot? Really? You can get an online script for weed in Texas? Let's find out. Weed prescription Texas online. Okay. Texas medical marijuana card online. Apparently I can. Who knew? greenhealthdocs.com, Texas medical marijuana card online. Join thousands of patients who have joined Green Health Docs to get it. We have a 99% approval rate. Hilarious. That can't be legal at the federal level. It's not. Let's ask ChatGPT what strains of marijuana are best for weight loss. Let's see if ChatGPT is confused by the request. Let's see if ChatGPT, well, actually, I'll ask Grok because Grok will probably, ChatGPT will probably get pissy at me because I'm asking about something illegal or something. Let's ask Grok instead. Okay. What strains of marijuana are best for weight loss? Okay, this should be good. Oh, Lord. Let's see what X says. Apparently, there are articles written about this. There have been articles written about the best ones for weight loss. Okay. No weed is for weight loss? Well, apparently there is. X is currently thinking about it. Beef Fish Bond Company. Brathilda for $5 said. Okay. While science is still evolving, strains high in THCV, such as Durban Poison, Doug's Varin, Pineapple Perps, and Willie Nelson, are frequently mentioned for their potential to suppress appetite and boost energy, which may aid in weight loss. These are typically sativa dominant strains known for energizing effects that could encourage physical activity. Wait a second, it's going to encourage physical activity and make me lose weight? Wow, this is the best marijuana ever. All right, cool. Hold on. Okay, yeah. Cannabinoids play a role in appetite metabolism. THC is notorious for stimulating appetite, while THC act as an appetite suppressant. A 2009 study published in the British Journal of Pharmacology indicated THCV reduces food intake and weight gain in rodents. But human studies, such as a 2016 trial on diabetes care, show no impact on human body weight in type 2 diabetes patients. Several strains frequently cited for weight loss due to high THCV content or other properties like energy boost and appetite suppressant. Below is a table summarizing key strains from mobile sources, including type, THCV content, reported benefits. Durban Poison type is pure sativa. THCV content is high, up to 1%. Appetite suppressant, energizing, reduces food cravings, boosts energy levels. Outstanding. Doug's variant. Appetite suppressant boosts energy, uplifts mood, stabilizes blood sugar. Wow, these are great. Pineapple perps, appetite suppressant, energizing, stabilizes blood sugar, uplifts mood. The Willie Melson. I mean, if you're going to name a drug after somebody, you know, why not? Uplifts, reduce cravings, aid in weight management, clear-headed high. The Jack Hewer, clear-headed, euphoric, supports appetite control. The Girl Scout cookies. Really? Girl Scout cookies is going to help me lose weight? Seriously? Euphoria, appetite control, pain relief, and energizing effects. Super Lemon Haze, energizing, mood lifting, supports active life. Sour Diesel, enhances energy levels, reduce craving, popular for weight loss. Okay. Charlotte's Web, appetite suppressant without psychoactive effects. Okay. So Charlotte's Web maybe is the one for me. Charlotte's Web is the way to go. It's an appetite suppressant, but doesn't have psychoactive effects. Okay. Northern Lights, relaxation, pain relief, no increased appetite, helps with mood. Oh, okay. All right. That's all good. So one of those strains apparently is the way to go for me. Excellent.
Wanted to see me. I'll see you at sidebar for just a minute.
Hold on, got to put the screen back. So apparently one of those strains is the way to go for my weight loss related needs. Who knew? Who knew? Weed makes you hungry, not these strains of weed, apparently. Senate Bill 3 bans THC in Texas. Oh, okay, well, that's the wrong direction. That's discouraging. So they're trying to ban THC in Texas, huh?
No, Chris, yes. Yes, I'm sorry.
We may have to move to a different state.
Some space here, please.
Hold 1 second.
THCV low levels is what you want? Okay. I have THCA delivered to my house. Excellent. Noted. Will it help me lose weight, Jules? THCA helpful for weight loss?
Okay, Paul.
Rise to the jury.
Jim, now you're going to have to go through all of those to pick the alternate out?
You okay with that?
Oh, okay. Okay.
Come up to Oklahoma. Our medical marijuana laws are crazy. There's a dispensary in basically every corner. It might as well be recreational here. Okay. Oklahoma's where it's at.
All right, jurors. I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict. But before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part one of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt.
You may find her guilty.
Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard, and heard in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence, they are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view is to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider three questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and/or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and/or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense, with that lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip That just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care, that is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death.
Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other four elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous to reach an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group.
Sorry.
Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you
said a lot
have
of things
any
I didn't
questions, please
understand.
feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate.
Heaven forbid
At
they
the
come
end
back
of the
with the
day, if
verdict
you're
during
still
the lunch break.
deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
I'm going to count the sidebar time as being part of the jury deliberation or part of the court instruction time. I had to debate whether or not to count that, I guess, but I'm counting it. So the instructions have now been going on for an hour, 1 minute and 30 seconds, and the clock is still ticking. Yes, a lot of these instructions are very standard. This is all model instructions. And if you're wondering why they're this long, it's because, well, basically the same reason the law itself is complicated, right? We tried to make the law simple, and then people found ways to break it and found ways to, subvert it. So we kept having to add to the law and kept having to add to the instructions because people kept finding ways to break things. So we had to explain things in extremely laborious detail because, well, basically, the long story short is basically behind every instruction, there's a case somewhere. There's a case somewhere that requires that because once upon a time, someone somewhere did a stupid. Are they literally doing dice? Because I'm here for it. Oh wait, they're doing it in court, open court. Oh, they're putting lots in a tumbler. I'm here for it.
Yes.
Sweet.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate?
Hey, it's a good way of doing it as any, baby.
Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And Juror 8, could you step down and take your place as an alternate?
Yeah.
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury and alternates in some separate but convenient place until they agree that you not suffer any person to speak to them, and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the
think
fullest
D20 would be
discharge of
badass,
your
though.
oaths as jurors. You may retire and deliberate your verdict.
Jurors, make sure you take your notebooks with you, please.
Exciting. Exciting. So the judge said they'd give them to like 5:30 today or something, so they get 3 hours. Yeah, I have a verdict. I'm ready to go. I can decide this thing in 3 hours. How fast can you give me the form?
I'm going to see counsel one more time.
We're doing sidebar? Why? Lord. Well, just because there are no jurors doesn't mean we want to say it in front of the public, I guess. What's the reason behind randomization? As opposed to doing what? It's the best way of doing it. I like that way of doing it very much. Yeah, you shouldn't know who the alternates are until the end. I like that. You draw the alternates at the very end by random lot. Why not? What's a better way of doing it? Works for me. Jin Decker for $10 says your personality is why I'm here. Sometimes you can sound very down. Yeah. And matter of fact, on things you can work on and change. Don't be so defeated. I think that'd help. Yeah, so don't sound as down. And matter of fact. Okay, I mean, I'll give that a shot. Trying to not sound as down is challenging because I suffer from depression, but I'll do my best to be more chipper and lively and all those things. I think I've improved, but we'll see if we can make it even better. So fair enough. What if they roll one? Well, one is a seat. So the only thing you'd have to account for is 19 and 20, right? And if you roll the same number twice, just re-roll. Yeah, so you just use a D20 and re-roll as required. D20 kicks ass. J.E. Walsh for $10. Thank you very so much. I have a small personality, a micro personality per se. I don't know what that means. I have a small personality? I don't know what that means. All right, so let's do something else while we're waiting. As we try to, well, I guess we'll stick here on the sidebar thing. Wellbutrin. I've used Wellbutrin in the past. I think I've got some Wellbutrin in my cupboard. I could go back on Wellbutrin, I guess. You think I should go? Yeah, you think I should just go back on Wellbutrin? Yeah, maybe I should just go back on Wellbutrin. I think I've got some in my cupboard. Zelda stream? Many documents to read? Cool. Excellent. Let's take a look. What do we got? Well, I see from stuff from Newsom. Is there something else? A separate OWI? Or I don't know if there was separate or not. You have a timer? Carnivore diet's been helpful for myself. I can't do carnivore diet. I haven't been able to stick to it. Did I get the switch too? No. So yeah, we're going to try to do some of the stuff on Karen Reed. Xanax? I don't think that's the answer.
Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory's not perfect, but I believe that we were going to have this redacted subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if defense
Okay.
wants to make that redaction, it can go into evidence.
Great.
I'll see if I have a Sharpie and maybe I can just take care of it.
I think we probably have one here you can have.
I definitely have one somewhere.
All right.
That's number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
You'll see that it's not what you provided me yesterday, Mr. Yannetti.
Thanks for $20 at Moves. That's very nice. We're going to read through, we're going to start by reading through Andrea Burkhart's Substack because I think she cited the cases that Judge Bev has been overruled in. So we're going to read her Substack and read the cases that she cited so we can get inside the mind of Judge Bev a little bit more. And we'll go from there, I guess. I've been on Well Breachin before. That's why I would have some in my cupboard. Because I would still have some from whenever the last time I was prescribed it. So, I could go back on it. I'm not taking anything for depression right now except Vyvanse, which isn't really for that anyway. So I could go back on Wellbutrin. I don't remember it like having a huge difference though. It wasn't like massive. So like it would be a pretty marginal change. But you know, maybe it's worth it.
Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them, yourselves, nor ask them if they agree, nor suffer them to disperse and then to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
Well, I'll give him my take on closing arguments. I kind of already did. Jackson's argument started off a little slow, but he got where he needed to be. I understand that there was actually a board of some kind in the courtroom that we couldn't see, where every time he laid a reasonable doubt, he put it on some sort of board. Because one of my like critiques that I said on X was I wish he had ended with like an enumeration of all the reasonable doubt. I think that would be nice. But if there was a board that people could see that listed all the reasonable doubts and he added to it one by one and showed it that way, then that would accomplish that objective. So assuming that that was correct, then his closing argument, I think I gave it like 9.3 on Twitter. But if there was a running,
So everybody else can sit down, Mr. Yannetti.
there's like a running deliberation or running enumeration, then like more like 9.8.
I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is...
Chat now trying to diagnose and treat my depression. That's definitely a good idea. Lol.
We are asking that there be not guilty options for each of the charges, including the offense charged and...
Thank you for the $10, Liz. That's nice.
Offenses. We really ran into the same issue last time. I think what complicates it is the fact that there are 2 theories for 2 of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
There's not a lot of case law out there even to support this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So,
with all
so
respect.
that's fine. So your rights are reserved. Does that help you?
Right, well, all we can do is object, Judge, and you make,
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple of things, Judge, is that we were provided with a clean
Laptop?
computer laptop. Thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right. Thank you.
All rise to the court, please.
We'll see if we can get a copy of the verdict slip, assuming that one is published, and we'll take a look at it. Okay. All right, let's see. Let's take a look at this Substack from Andrea Burkhart. Andrea's smart cookie. Andrea wrote, if Karen Reed is convicted, we'll stick on appeal, probably. I looked into Judge Beverly Cannone's kill record and published decisions. She doesn't always get it right, but that doesn't mean the reviewing courts will fix it. Yeah, that's definitely not necessarily the same thing. That's true. From pretrial rulings through evidentiary decisions made in the course of the trial, there are a lot of legal issues that present ripe grounds for appeal. Thank you, whoever that is talking over me. From pretrial rulings through evidentiary decisions made in the course of trial, there are a lot of legal issues that present ripe grounds of appeal in the perhaps unlikely event that Karen Reed is convicted of a crime. Back in week 3, I mentioned on stream that I did some research into Judge Cannone's appeal record, found some very interesting nuggets. I'm going to share them in full now. This review is based on appellate decisions in which Judge Cannone was the trial judge. The Court of Appeals publishes this when they want the decision to have precedential value because it provides clarity on a new or complex issue of law or gives guidance on lower courts on how to apply the law in certain factual situations that are likely to occur. Most appellate decisions, however, are unpublished because they involve routine application of everyday law to everyday situations. Because I could not search unpublished decisions with the tools I have, some databases have them, some don't, this review does not cover all Judge Cannone's decisions that were later reviewed, only decisions that were considered enough to be precedential. I mean, we do still print books. So we do have to be concerned about, the books because there's only so many pages and shelves and stuff. Okay, overview. Judge Cannone gets it right a little more than half the time. I found 10 published appellate decisions of Judge Cannone's rulings that were issued between 2017 and the present. So that's over the course of what, 8 years? They consist of 3 civil cases and 7 criminal cases. Of those 10 cases, she was affirmed 6 times and reversed 4. In 6 of those 7 criminal cases, she originally ruled in favor of the defendant, and 3 of those decisions was later reversed. The one time she ruled in favor of the Commonwealth, she was affirmed on harmless error grounds. The record intrigued me because she does not show a particularly prosecution-friendly judge. Historically, she's not ruled for Commonwealth on a knee-jerk basis. In fact, she's often been reversed for being too receptive to defense arguments. This paints quite a different picture of her instincts than we might expect if we all saw her decisions in the Karen Reed trial. Breaking down decisions, she's more influenced by facts than law. Well, that's not necessarily super promising for a judge. When it comes to parsing technical statutory and deciding what it means, Judge Cannone doesn't have a great record. That is somewhat discouraging. She's been reversed for incorrectly interpreting the requirements of a civil commitment statute, the mechanics lien statute, and expungement statute. In cases where language establishes unambiguous requirements, such as the length of a probation term, the service requirement for a citation, or form selection clause in a contract, she does a bit better. A bit, you say? A bit better where it's unambiguous. That's good news. Why am I not a judge yet? Seriously? I mean, Why am I not a judge? I cannot be as bad as some of the judges out there are. I'm breaking up? Seriously? Really? Or do I have a problem? What bullshit now? Okay. I look softened. I don't know what that means either. Oh, you mean the image quality is softened. Okay. All right, pressing on. The facts seem to influence her legal reasoning heavily, but not always in the right directions. It's not the camera that's the problem. It's the bit rate coming out of Restream. That's the problem. Restream sometimes seem problems with the bit rate. Maybe that's why they charge half of what StreamYard charges. Maybe it's because they're just not as good. Maybe I should pay the $50 a month for StreamYard. StreamYard is expensive, but maybe they're better because we've been having issues with bandwidth coming out of Restream. Or maybe we shouldn't just multi-stream. Maybe we shouldn't multi-stream at all. If we just streamed out of OBS, we would not have these problems either. We'd have great issues streaming out of OBS. Anyways, going back to my earlier point, why am I not a judge? Like, I can't be that bad. I'm not saying I'm God's gift to judging, but I can't be as bad as some of the judges that are out there. Surely, I can't be as bad as some of them. What am I multi-streaming to? At the moment, I am multi-streaming to Twitter, Facebook, and Twitch. Not that anyone's really watching anywhere of those places, but, well, some people are watching on X, actually. But that's where I'm multi-streaming to, so yeah. All right, let's press on. StreamYard is just too expensive. They want too much money. Is Rumble available? The problem with Rumble and locals is you have to set up the stream every single time inside their software, and it's a real fucking pain in the ass. With like most of the services, you don't have to do that, right? You don't have to set up the stream every single time. You just create the stream in one place, and you can just, like, I don't even have to create the stream at all in YouTube to stream to it. I can just create a stream on the fly. But you can't do that with Rumble. It's a real fucking pain in the ass. The facts seem to influence her legal reasoning heavily, but not always in the right direction. When a defense lawyer failed without good explanation to investigate a third-party culprit defense based on an eyewitness statement of a confidential informant produced on the eve of trial, Judge Cannone's decision to grant a new trial was affirmed. But when an 80-year-old man, $50 a month isn't much. $50 a month isn't much. I don't really appreciate being told what is or is not a lot from my own frame of view. That's not very polite, Miss Shorty. If I think it's a lot, then it's a lot. Unless, of course, I'm not entitled to my own opinion. Am I entitled to my own opinion? Am I allowed to think that $50 is a lot or not? Please let me know if it's okay for me to think it's a lot. Let me know if that's acceptable. But when an 80-year-old man in a wheelchair alleged to have been sexually violent person was confined pending a jury trial when jury could not been during COVID. Why so spicy? Fuck you, that's why. Similarly, her decision to grant expungement to a petitioner who had been crime-free for 34 years and could not pursue his profession with the conviction on his record was reversed because her records did not satisfy statutory requirements for production. Do I practice law currently? Currently, I just filed a notice of appearance in a case. What does that have anything to do with anything? When a plaintiff sued insurance company for deceptive settlement practice, Judge Cannone found that the plaintiff had exaggerated his injuries and lacked credibility, but nevertheless agreed the insurance company had behaved deceptively. Is it okay for me to think that it's not a lot? Yeah. I don't recall telling you. Yeah, I mean, that's fine. $50 Australian is equal to $86 US. That's exciting information. That is in no way relevant to me, but noted. Okay, noted. You are happy paying that rate. Great. Thank you. That's fantastic. I don't care. I don't care what you're happy paying. I'm thrilled for you. Pay what you want. It's your money. You can value it any way you want. Knock yourself out. Go crazy. Stop letting people piss you off and get you off topic. I will time you out because you got me off topic. Yay. All right, great. Let's see. One decision stood out to me, especially noteworthy in live rulings she's made, is Commonwealth versus Karen Reed. So let's take a look at it more recently. Commonwealth versus Travis side 2023 is a capital murder case. The victim was an alleged drug dealer who was shot and killed. Mr. Tavares was the last person to call the victim. His phone pinged off the tower closest to the victim home. At the time of shooting, the fingerprint was on the door. Why am I so mad? You get timed out. Okay, great. In a police interview, he admitted previously disputing with the victim a price of marijuana he bought and texted, "Yo, I got bagged." However, two eyewitnesses present in the area did not identify Mr. Tavares. Tequila? Are you seriously telling me to drink, Travis? Seriously? However, two eyewitnesses present in the area did not identify Mr. Tavares as a shooter in a photo lineup, and the police did not recover the murder weapon in the shooting of his home. Mr. Tavares contended that he was not the shooter. Shortly before, prosecutors disclosed that a confidential informant had revealed during a proffer that two different men were responsible for the shooting. They had gone home to rob the victim and shot him when they lunged for the gun. The proffer agreement was turned over to the defense lawyer the day before the trial started, and the trial lawyer never interviewed. Trial proffer agreement was turned over to defense lawyer the day before trial started, and the alleged third-party culprit was ordered by the court to be available for trial. But the trial lawyer never interviewed the suspect or conducted any investigation into the information the confidential informant provided before proceeding trial. Mr. Tavares was convicted. Judge Cannone found that Mr. Tarvis's trial attorney provided constitutionally ineffective assistance in granting a new trial. She rejected the attorney's explanation he didn't ask for to investigate the new information because he wasn't sure if his other witnesses would be available later, pointing out that they weren't good witnesses anyway because they didn't provide Mr. Tavares with an alibi. And she concluded the decision not to investigate deprived Mr. Tavares of viable defense because the investigation would support both Bowden and conventional third-party culprit defenses. Her reasons and conclusions were affirmed on appeal. I found it intriguing that Judge Cannone had such a recent high-stake experience with third-party culprit issues in light of her obvious implications in Karen Reed. Although this for evidentiary rulings is often obscure, since she's instructed the attorneys not to state the basis for their objections, she has sustained several Commonwealth objections on grounds that appear to me to relate to her pre-trial determination there's insufficient evidence of the involvement of Brian Higgins, or Colin Albert in the death of John O'Keefe to bring questioning about it. This determination is perhaps a bit more understandable if the Tavares cases are standard. An eyewitness who directly implicates third parties not emerged in the Karen Reed case, but the Tavares case isn't the legal standard, so it remains to be seen if the limit she's imposed on defense's ability to argue that Brian Higgins and or Colin Albert caused John O'Keefe's death and try to cover it up will be as reasonable by reviewing court in light of Karen Reed's unquestionable constitutional right to present a defense and confront her accusers. What does this mean for Karen Reed? When it comes to discretionary decisions like evidentiary rulings, the appellate standards are very forgiving to the trial judge. Even discretionary decisions can be reversed if they're based on erroneous understandings of what legal requirements are. And when it comes to interpreting legal requirements, Judge Cannone's record isn't that great. To the extent any of her rulings can be criticized on grounds of legal misunderstanding, that ground is likely to be more fruitful than a straightforward challenge to reasonableness. Well, no shit. I mean, I could have told you that anyway. I mean, that's just inherent. If the standard is abuse of discretion, then no shit. Versus legal error. Yeah, I mean, duh. That's just inherently true. That's always true, right? If her rulings are legal understanding, in other words, she got the law wrong, then de novo, and it'll be reversed. But if it's based on abuse of discretion, then not so much. So yeah, that's just true. I mean, of course it's true. That said, when Judge Cannone rules for the Commonwealth, it rarely goes wrong for her. On the one occasion, she was found to have committed error bias in the Commonwealth's risk assessment tool in a sexually dangerous person commitment trial. That error was found to be harmless. Harmless error allows judges to make numerous errors in a case, so long as the case against the defendant is so strong they would have been convicted anyway. Harmless error analysis gets you a long way as the government in an appeal. It sure does. I'm not sure the case against Karen Reed reaches that level, at least not based on evidence presented. But harmless error also requires a challenge to prove the consequence of the ruling. And when the ruling is a decision to prohibit certain questions, that can be impossible because the answer is of course, unknown. But there is a way to solve that problem, at least in principle, right? The way to solve that problem is by making an offer of proof, right? So the way you solve that problem is like, oh, if I had asked this question, this is the answer I would have gotten. So you can solve that problem by making an offer of proof, and that would work. The unfortunate lesson to be drawn from Judge Cannone's record appears to be that ruling for defense is more likely to get you reversed in Massachusetts. Apparently, on many occasions, she's gone out on a limb in favor of it and drawn a slap on the wrist in return. It's only natural a judge would learn the risk of ruling for a defendant is unlikely to bring a reward, while ruling for the Commonwealth even erroneously is likely to stand up. This may account for some of what's appearing to be more and more judicial preference for the positions and practices of the Commonwealth in Judge Cannone's decision and does not paint an optimistic. I tend to agree with all those things. I think all those things is true. And I guess we will look up some of these cases in which she has been reversed or whatever and see what it has to say. Are these all appellate cases, I guess? I guess they are. All right. So there's like 10 different cases to do a legal review of? Oh, Lord. This is going to take a hot minute. All right. All right, let's start with this case, I guess. It's good as a place to start as any. I wish I could make my, can I make my windows different? Oh, Lord. Can I make it any bigger? Put myself in the corner. I guess I'll put myself in the corner so I can get the text on screen. Make it bigger. All right. We didn't do we had some super chats today. How are we doing in terms of members, subsequently? Let's take a look and see where we are in terms of subscriber count. Yeah, Andrea Burkhart's got 10,000 people watching her. I've got 500, so she's outperforming me 20-1. That's exciting. Let's see. We're at 149,704. So we need another 296 people to hit subscribe. So if you could get 296 of your friends to hit subscribe, that would be helpful and appreciate it. Thank you. All right, so this is an appellate decision involving Judge Beff, I guess. Have I made the stream for the interview with Broken Baker? Well, when's that supposed to happen, Jinx? I forgot. We have an interview, and if it's happening during trial watch, they can just join me during trial watch. All right. Let's see. If trial petition by Commonwealth pursuant to some law seeking commitment of defendant as a sexually dangerous person, although the judge did not err in admitting testimony of two qualified examiners, defendant likelihood of reoffense. The judge did, this is talking about Judge Cannone. The judge did err in admitting their testimony regarding defendant's risk cable category labels on the risk assessment tool. Defendant had a moderate, high, or high risk of reoffense, where such testimony does not aid the jury in determining sexual dangerousness, in that the meaning of the labels is often clear. There's an absence of accepted standards for measuring the labels to specific meanings, and substantial variation exists among sex offenders ascribed via labels. However, given the limited nature of the use in the qualified exam overall risk assessment, the error was non-prejudicial. Okay, I mean, that sort of makes things. So there was a paper that had a label on it that said this person is moderate, high, or high risk, and she allowed that label. And the Court of Appeals wasn't thrilled, but they're like, we don't care enough to do anything about it. So that sort of makes sense on that fact pattern. All right, what else do we have in terms of things? Let's take a look at EC, I guess. I need some water. Give me a second, please. I need to get some water. I was just saying I don't need my earpieces in right now, so I'll just keep them out. Okay. All right, cool. More water for uncivil. Excellent. All right, let's discuss this case. See, a district judge, again, Judge Beverly Cannone, abused her discretion in denying a motion to Bridgewater State Hospital to amend petition pursuant to relevant law for an extension of the commitment of a criminal defendant who had been found not competent to stand trial to a petition for a civil commitment pursuant to law, where the hospital filed its motion immediately upon learning the criminal charge pending against the defendant had been dismissed, and where under a statutory scheme, dismissal of that charge did not negate hospital's authority to hold the defendant while hospital's petition for extension was pending or require immediate release from the defendant from commitment. I mean, okay, I guess it makes sense. DDB confirmed your take on third standalone DWI. So there's now a standalone DWI charge. It wouldn't be listed as, or would it be? There's a standalone DWI charge. Yeah. Until I see the verdict form, I'm not going to believe it, to be honest. You know, I want to see the verdict form to see that that's correct. So if anyone happens to see the verdict form floating around Twitter, let me know or something so we can verify that. I heard Bev read it out loud. I still want to double check just to make sure. I just want to make sure I heard it correctly. Will Karen be able to claim anything in regards to spending for proceedings? No. 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 A superior judge, again, Judge Cannone, properly dismissed indictments charging the defendant with various motor vehicle offenses when the state police trooper defended a copy of the citation at the time and place of violation, where a 9-day delay in issuance of the citation, absence of any justification, contributes to anti-abuse purpose of the no fix provision. Emily D. Baker could have made a mistake. I mean, I'd like to see it for myself. If that's, I'd like to see it, please. Emily D. Baker's wrong. She might be. I'd like to see it for myself. We all make mistakes sometimes. I certainly make mistakes. A claimant seen to enforce a target lien bond by commencing a civil action pursuant to mechanic's lien is not required to record an attested copy of the complaint in the registry of deeds within 30 days of the action. In the plain language, the statute contains no such requirement, in contrast to another section of the chapter that explicitly requires such recordation. Okay. And given the legislative history, support a reading of the statute is not inclining such a requirement. So her ability to interpret the statute apparently is not so great. She's not so great on the reading the statute's requirements. I started using EV Mux because it allows multi-stream 2-host, 12 gas, and a lot of automated features. Well, let's take a look at EV Mux and see if it is the solution to my multi-streaming needs. Let's take a look and see if it is the solution to my multi-streaming needs. I'm feeling a little down. I don't know why. Sometimes things just put me on the wrong path and you just wind up on the wrong side of the curve. I don't know, man. I'm sorry, guys. I feel like I'm not being fair to you in some ways. I apologize. This right now is the reason why my stream isn't more popular, isn't it? Yeah, probably. All right, let's take a look at EV Mux. What the hell is this? The best way to record streams and record a whole bunch of stuff. Revolutionary web-based live streaming and recording studio. Multi-stream to Facebook, YouTube, and others. Oh, just shift your energy. Just shift your energy. I want to punch you in the face. Yeah, the biggest news drop right here, Kurt. What's that, Janine? What is the biggest news drop? Do you find either odd or suspicious that Bev picked a four-person before the alternates? Apparently, that's just the way they do it in Massachusetts. I don't know what else is going on. Fully branded live streaming. That's nice. You have them here? Okay. Web-based streaming, recording content. $19 a month. That's basically what I'm paying now. Mulling to 4 destinations. 12 screen participants, pretty good. What resolution can I stream in? Does it say? Oh, even for free, you get to stream in 1080? Oh, that's nice. Because Restream only allows for 720. Do you get full 1080 streaming from this service? That alone makes it like a good idea. That makes it a deal. You get full 1080 streaming. That's a good deal, man. Pro scene builder. Create fully customized scenes. Oh, that's good news too, man. Because you can't create my scenes in Restream, which is really fucking annoying. I don't think you can create streams. I don't think you can create scenes in StreamYard either. But you can create scenes in this. Oh, that's nice. That's excellent. Logo background. You can do a slideshow. Unlimited streaming. Stream up to 6 hours each live. I'm gonna need more. Yeah, 6 hours each. 6 hour live is not enough. I need more than that. So at the 39 option, can I stream more than that? No. Yeah. Okay. So this service will not work. This service will not work because it's a stream limit of 6 hours. So I appreciate whoever suggested EV Mux to me, but it will not work for me because I need longer stream times than 6 hours. I have 6.5 hours already. 6 hours 40 minutes so far though. So no good for me. No good for Uncivil. A single justice did not err in denying the motion to dismiss an appeal for lack of jurisdiction due to plaintiff's failure to file notice of an appeal following denial of motion for reconsideration, where a later motion was not timely for the purpose of law, where at any rate that motion, which only sought reconsideration of the allowance of the motion dismiss, was not a motion that would toll the time period for filing a notice of appeal, and where the plaintiff's first notice of appeal filed within 30 days of the lower court's entry of dismissal conferred jurisdiction. Yeah. A contract's choice of law clause, which provide for substantive law of Connecticut to govern contract, was unenforceable. Everyone is autistic. We're on the spectrum as differentiator. It's not a bad thing. I disagree with your contention. Everyone is autistic, and whether or not it's a bad thing is up to me to judge for myself. So I don't agree with either of those things. In a civil action for breach of contract brought in Superior Court, the judge did not err. You cannot force me to accept a label onto myself. You cannot force me to accept a label I don't want. That's very rude. To try to impose a label on me, that's very rude. Let's see. Haven't we had this conversation more than once? In a civil action for breach of contract in Superior Court, the judge did not err allowing defendant's motion to dismiss on the basis that the contract contained a form selection clause that provided that any action against defendant be brought in Connecticut, where under Massachusetts law, the plaintiff failed to meet its substantial burden of showing enforcement of the clause would be unfair and unreasonable, given that it was reasonably communicated to and accepted by plaintiff, given the principals were sophisticated business people and no claims of fraud in the contract's execution, and given that it would not prevent the plaintiff from providing testimony to the Massachusetts witness. Yeah, I mean, form selection clauses are pretty typical in contracts, so the judge saying, the form selection clause is invalid, not really. If it's anything even approaching reasonable, not much. All right, what else? A superior judge properly allowed a criminal defendant's motion to dismiss a probation violation, where the alleged violations occurred after probation term had already ended. Okay. In that the language of the initial sentence unambiguous stated probation was to begin from and after the incarceration on another offense, rather than defendant's release into the community after serving a 10-year period of civil commitment as a sexually dangerous person, and that despite the defendant's directly inconsistent position taken in a sexually dangerous person trial, judicial estoppel cannot apply to extend the length of a sentence already imposed. I mean, that seems plausible enough. A superior court judge erred in granting a sex offender. Why are there so many sex offender cases? Like, why offender cases, man? Damn. A superior judge erred in granting a sex offender's motion for a bench trial petition for release from civil commitment to the Massachusetts Treatment Center as a sexually dangerous person, where the Commonwealth's exercise of its statutory right to a jury trial on the petition did not constitute a violation of the petitioner's substantive due process rights, given it was narrowly tailored to advance Commonwealth's legitimate and compelling interest in protecting the public from sexually dangerous persons, and given that the delay in scheduling a jury trial resulting from COVID did not transform the exercise of the right into conduct that shocks the conscience, particularly right petitioner's continuing commitment after a single mistrial. I mean, okay, fair enough. I should just ban the word autism and autist from chat. That's what I should do. That is the only solution to this problem. I'm going to just ban it from chat because this is some bullshit. Excuse me. I'm going to go into YouTube backend and add it to the banned words list. Give me one moment, please. It is apparently not. Did I show the verdict slips? Haven't seen them yet. Is a copy available? Okay, here's the blocked word list. Okay. Autism and autistic. What else should we do? Spectrum? What else needs to be on the list other than autism and autistic? Can I read the list of banned words? No, but I can tell you to fuck off. If I use spectrum for other things, figure a different word, I guess. All right. Trying to make you smile? Okay, well, fuck off. Red Hat Maverick. Let's see. All right, so we read that one. What else? Tism. We can add Tism to the list. Okay. Love you. Thank you. All right. Let's see what else we got here. In a case, an action brought by Superior Court by plaintiff who would attempt to negotiate a settlement with a liquor liability insurer for serious injuries suffered in a fight that occurred after he and two men who had assaulted him participated in a tournament at a sports club, ample evidence support the judge's conclusion that issuer violates his obligation to conduct a prompt and reasonable investigation by cherry-picking facts to support its initial position. The insured liability is doubtful, and by discarding or at least diminishing the significance of a considerable amount of contrary information. Further, judge correctly applied the appropriate standard, determining that liability was reasonably clear. Two men who assaulted the plaintiff were visibly intoxicated when they were served alcohol at the pub, and they were aggressors in the fight. And there was no error in judge's determination that despite plaintiff's lack of credibility, defense settlement offer was unreasonable, given uncontroverted objective evidence. Okay. Okay. All right, so I think I see Jordan wants to get banned. I see. That's fine. Yep, Jordan wants to get banned. That's fine. Jordan is now banned. That was fast. Some people don't learn. That's okay. We can teach them faster. I have the technology. How long do I think jury will deliberate? I have no fucking idea. The odds of them reaching a verdict today, though, are reasonably decent because it's a Friday, and Fridays tend to, although it's a lot of information to go through, but if there was going to be a quick resolution, Fridays encourage that. Was Brennan's close as good as the opening? His first half left a lot to be desired. The second half was much better. My last percentage is still 20%. There's a new verdict slip? Great. Where can I find a copy of it? We'll discuss it. That'd be great. Oh, yes, I was supposed to confirm when an interview was going to happen. I forgot. Because I got distracted by other things. It didn't provide a specified time. I'll just drop them the link and they can join whenever. Okay. Did I order the mimosa agreements? No, I decided not to. I decided it wasn't worth it. No verdict slip has been released yet? Okay, so then I can't discuss so because it doesn't exist. Okay, so what should we discuss since there's no verdict slip? What should we discuss? Coming up streaming schedule. Yeah, there's no streaming schedule. I think we're going to be doing edited videos, probably releasing them, towards the end of the day, 4 p.m., something like that. Any interest from a Supreme Court 5-0? Sure, why not? It can't be a 5-0 unanimous. That's not possible. A 5-0 unanimous opinion from the Supreme Court is not possible. The 5 unanimous since the 5 unanimous decisions. Oh, okay, that makes more sense. Let's see. Have I discussed the reasons why defense bailed on missing witness instruction? What if 4 recuse? Then the Supreme Court can't hear the case. You need at least 6 members to hear the case. That's why a 5-0 unanimous is not possible. You can't hear the case with only 5 people. You need 6. That's why. Is it below quorum? Yep. Nice tea. Oh, there was a decision yesterday. A couple decisions yesterday. Yeah, there's a couple decisions that dropped yesterday, it looks like. Was there like 4 opinions that dropped yesterday? Whoa, yesterday might have been Big Scottish Day. A lot of things dropped. Okay, hold on. What's going to happen in the case that has 5 recusals? The lower court decision stands. That's it. Lower court decision stands because there's nowhere to go. Oh yeah, there were several decisions yesterday. There's like 5. There's 1, 2, 3, 4, 5, 6 decisions yesterday. Excellent. 6 Supreme Court decisions. Good shit, man. It's time for Supreme Court decision time. Supreme Court decision time is glorious time for you and me, man. Outstanding. 6 decisions yesterday. Cool. It is that time of year, baby. It is that time of year. It's the most wonderful time of the year. Ding dong. Possible guests for my stream. I sent out links to like basically everybody. So, oh, and incidentally, I can't hear if someone joins the stream because I don't have the thing in my ear, so I can't hear. So I have to put the thing back in my ear in case someone joins. Do I have any thoughts on the Israeli thing? Does the Israeli thing have legal implications? Then not really. I don't do politics. I do law. I don't really discuss politics. I discuss law. That's what I do. Is there any limits on retrials? No. All right. We turn our attention to the U.S. Supreme Court. Can I make this any bigger? Yeah. We turn our attention to the U.S. Supreme Court in the case of AGT versus OSA area schools, in which the Supreme Court opines the following. Multiple federal laws afford protections to children with disabilities in public schools. They sure do. 3 statutory schemes are particularly relevant in this case. Section 504 of the Rehabilitation Act of 1973 provides no qualified individual with a disability shall be excluded from participation in, denied benefits of, or subject to discrimination under any federally funded program solely because of reason of his or her disability. Similarly, Title II of the Americans with Disabilities Act prohibits qualified individuals from disabilities from being excluded from or denied the benefits of a public entity services, programs, or activities by reason of a disability. While the anti-discrimination guarantees of Section 504 and Title II apply in various contexts, the Individuals with Disabilities Education Act offers federal funds to states in exchange for commitment to furnish the core guarantee free appropriate public education to children in public schools with certain physical or intellectual disabilities. The centerpiece of the IDEA law is the provision of individual education programs. We're probably pretty familiar with this concept, I'm sure, which spells out a plan to meet all the educational needs of the child with a qualifying disability. Petitioner AJT is a teenage girl with a rare form of epilepsy that severely limits her physical and cognitive function. She suffers from seizures that are so frequent in the morning, she cannot attend school before noon, though she's alert and able to learn from noon until 6. For the first few years of her schooling, school officials accommodated AJT's condition by permitting her to avoid morning activities and instead of evening instruction. But when AJT's family moved to Minnesota in 2015, her new school district, the Odessa Area Public Schools Independent School District number 279, denied her parents' repeated requests to include evening instruction in AJT's individual plan. Between 2015 and 2018, AJT received only 4.25 hours of instruction daily compared to the typical 6.5-hour school day for non-disabled students in the district. After even further cuts to AJT's school day were proposed, her parents filed a complaint with Minnesota Department of Education alleging the school's refusal to provide after-hour instruction denied AJT appropriate public education. An administrative law judge determined the school's district had violated the IDEA Act and ordered the school to provide compensatory education and evening instruction. Federal court subsequently affirmed AJT's IDEA Act victory. AJT and her parents then sued under the Americans with Disability Act and Rehabilitation Act, requesting permanent injunction, reimbursement for certain costs, and compensatory damages. The district court granted summary judgment for the school, and the 8th Circuit affirmed. In so holding, the 8th Circuit stated, the school district's failure to provide a reasonable accommodation was not enough to state a prima facie case of discrimination under Minea versus Nebraska, which requires a plaintiff to prove conduct by school officials rising to the level of bad faith or gross misjudgment. Yeah, I already know where that's going. Held, school children bringing ADA and Rehabilitation Act claims related to their education are not required to make a heightened showing of bad faith or gross misjudgment. Well, no shit, Sherlock. Right? No shit, Sherlock, under that question. Right? Some court of appeals imposed some new exciting bullshit. In addition to showing that you're discriminated against because of your disability and that there is a reasonable accommodation that could accommodate you, that you're not being provided, which should really be enough, right? In addition to this fun, exciting stuff, the Court of Appeals is like, well, you also have to prove bad faith or gross misjudgment. If it wasn't bad faith, it's totes cool, yo. No, that's not what the law says, you jackass. It's not what it says, damn it. Let's see. Outside of educational services context, Court of Appeals permit plaintiffs to establish violations. What do I think on Karen Reed after closing argument? Before 20% to convict is my best estimate. Outside the educational services context, Court of Appeals permit plaintiffs to establish violations and obtain injunctive relief under the ADA and Rehabilitation Act without proving intent to discriminate. Right. So why would it be different in the educational context? That doesn't make sense. To obtain compensatory damages, courts generally require a showing of intentional discrimination, which most circuits find satisfying by deliberate indifference. A standard required only a showing that the defendant disregarded a strong likelihood that challenged action would violate federally protected rights. Nothing in the text of the applicable substantive protections or remedial provisions of Title II suggests that claims based on educational services should be subject to some distinct, more demanding analysis. So if you just want the problem fixed, then all you have to show is you have a disability that could be reasonably accommodated that is not being reasonably accommodated. If you also want compensatory damages, then you need to show deliberate indifference or intentional discrimination. So if you want money, then you need to show intent or willful indifference, deliberate indifference, but not some new heightened standard otherwise. The standard typically. Let's see, pressing on. Some courts, however, have come to apply some exciting heightened intent standard that they got from some bullshit place to the ADA and Rehabilitation Act claims in educational services conduct. Why? Why did you do? Where are you coming from? From where are these additional bullshit requirements coming from? Court of Appeals. Did the ADA or the Rehabilitation Act have a section that said, "Oh yeah, by the way, in the case of education, here's the law"? Did it say that? No, it didn't say that. Then why are you coming up with these exciting requirements? From whence are the exciting requirements coming from, courts? We can't find them. You bullshit piece of shit. This standard traces back to the bad faith or gross mismanagement rule articulated by the Eighth Circuit in the 1982 decision of Monahan, in which the Eighth Circuit reasoned that to prove discrimination under the Rehabilitation Act in the education context, a plaintiff must show something more than mere failure to provide a free, appropriate public education. But why, though? The court explained a heightened showing of bad faith or gross misjudgment was necessary to harmonize the Rehabilitation Act and the IDEA Act. What? And to reflect the proper balance between disabled children's rights, state officials' responsibilities, and courts' competence in technical fields. Okay. All right. In Smith versus Robinson, the court similarly tried to harmonize, and they put that in quote marks, so you know you're in trouble. Similarly tried to harmonize the... Are you guys enjoying this, by the way? So there is a verdict form. There is a verdict form. Okay, fine. So where is the verdict form? What channel has it? And I will go look at it. Where on X do I get it from? Great. Which channel? I will go back to Karen Reed. Just tell me what the name of the person is, and I'll go pull it from their channel, from their X. Who is it? Who is the what account? Anybody want to tell me? I'll just wait. It's on Discord. Okay. The free Karen Reed account. Okay. Wow. This one's a little more complicated than last time. Okay, that makes things interesting. All right. All right. I'm working on it. All right. How do I open this thing up? Do I have to switch windows to do this? I don't want to switch windows to do this. Let me pull it from Twitter so I don't have to switch windows to do this. I told you earlier. Well, people were telling me different things at different times. So I did my best. It's in staff. I can't pull it up in my browser from staff, so I'm going to have to pull it up differently. Once again, can't pull it up that way. I'm trying to do something else. Can't pull it up that way. Trying to do something else. I'm now trying to find it on the free Karen Reed like Pixel. I'm still trying to do something else. So it's on the free Karen Reed channel. I don't see it on free Karen Reed. Don't see it on that channel. You said it was somewhere else? Hello, how are you doing?
I am, 32 days in. We are all bored, I think.
All right, we'll try this Katie Benoit account and see if I can pull it up that way. All right, let's take a look at this verdict slip. All right, so here's the verdict slips that we have. 3 verdict slips for three charges. Count 1, offense 1, murder in the second degree. Simple enough as it goes. Not guilty or guilty of the charge murder in the second degree. I mean, that part's the easy part. And then count 2. Holy shit, it's going on. Did they manage to actually squeeze it all on the page? It looks like they did. Damn. This is, yeah. So this is kind of the same as last year, I think. I think this might be exactly the same as last year. I'd have to double check, but it looks very similar. Not guilty of the offense charged or any lesser offense. Guilty of the offense charged. Manslaughter while operating a motor vehicle under the influence of liquor, checking one or both. Guilty of lesser included involuntary manslaughter. Guilty of lesser included motor vehicle homicide. Guilty of the lesser offense operating under the influence of liquor. So yeah, we just apparently have a naked DUI charge. So that's an additional one. So that is a new one. We have a naked DUI charge.
And I think she'll get convicted on that one based on her interviews.
Yeah, that seems very plausible. Interesting. That's gonna do wonders for the betting market, though, because we have to like reassess completely now, and the betting markets need to like reassess completely, because the way the bet is written for like conviction, it's like count 1 or count 2, and count 2 just got new exciting counts. So the betting, this is your time to make some bets, guys, because there's some, as people are learning this information, there's some serious arbitrage to be had. So the probability of conviction on count 1 or count 2, I don't even know what it is now. I like have to like recalculate massively. Like the probability of a conviction on count 1 or count 2 is now, I don't even know, 90%.
On count 1, I don't think she can get convicted.
There's no DUI charge. I'm literally looking right at it, J.E. Welsh. I'm looking right the fuck at it. It's number 5. It's on the fucking page, J.E. Welsh. Look at it. It's number 5.
Yeah.
They call it operating under the influence of liquor. That's DUI.
Yeah.
It's DUI. They call it something different in that state. They don't use the acronym DW. They don't use the acronym DWI. Different states call it different things. It's DWI.
And again, putting that in there, which I think is, well, it's not like they haven't done bad stuff before, but I think,
that's DWI. Yeah, exactly.
Yeah.
It's just called different things in different states. It's DWI. And probability of conviction is now 90%. Tell your friends. In fact, I have to make a tweet. I have to make a tweet to tell people. I guess I'll retweet this thing. So I'll save this image as. Hold on. Talk amongst yourselves while I do this real fast.
no, Jay Walsh, this is all the lessons in count 2, not count 1. And I don't believe last year they had a clean OUI, DUI, whatever you call it.
Yeah, this will make people really happy. Just tweet probability of conviction carried on count 1 or count 2 is now 90% because there's a bare OUI, aka DWI charge. For those you following Polymarket now, would be a real good time to get some bets in. I think. Lol. Yeah. So that changed the probabilities massively. So you're tired. I'm tired. I'm not completely lucid.
I got the vid while I was in the States, so I am feeling hunky dory.
Why don't you tell our beautiful chat, who are you?
I am the Broken Baker, a Danish layman. That's our jury system, and that's why I cover court cases, because in Denmark we have this system where we get elected 4 years at a time to do layman duty, and I am in the lowest level on the court where you can get anything from 14 days to 6 years. So I do a lot of, especially drugs and violence cases is mostly what I have to sit and be the juror on. So, yeah, I've been doing this for the last 14 years.
It is not the same slip as last year, J.E. Walsh. It is just not the fucking same. It is not the same. They added in the count. I'm going to time you out if you continue with misinformation. It is not the same. I can fucking read, and I'm not saying it again. God damn it.
So yes, that's what I do on my channel, is sit and watch it. Instead of with a lawman's perspective, I watch it with a layman's perspective.
Excellent. Well, I'm glad you're enjoying all those things. What did you think of the closing arguments today?
Well, I got in trouble because I didn't rate Alan Jackson as high as apparently we had to say it was the best ever. I found it a low B, high C. I didn't think he went over the charges enough and why they could find her, especially with this charge form. I would have gone through each and every one of these lesser charges and say you can't find her guilty in any of this. I think the biggest problem with me from the first trial has been the third-party culprit. It gets too much in the weeds for a jury. It leaves them way too many options, and I have an idea that when juries get options, they'll go back to the safe haven and said, no, we'll just go with what the state says. So I gave him maybe a B minus, and Hank, I just disliked that a-hole, so I gave him like an F. Which is probably a little low, but still, I didn't like it. And
he was really bad in the first half.
Yeah, and his ending, it felt like, because again, if there had been an audio cue that you have to wrap it up or something, I could understand his ending, but here, John is not a thing. John is a man. John is not a buffalo on the prairie. And then he just sat down. Normally, you would do the thank you so much. You have to go back and find her guilty. Something. He just sat down. It seems so weird. But he's been. I talked to Andrea Burkhardt about this before. Back when the case started, where I said, I think his biggest problem is he's a defense lawyer, and defense lawyers don't make good prosecutors because it's a different role you have. You have to attack. You have to be. Fight for your client. You don't do that as a prosecutor. A prosecutor just gives you the facts in the perfect world. But I think he showed in his closing that he's a defense lawyer. He's not a good prosecutor.
Mm-hmm.
That's my take on it. And again, I see this as a hopefully like a juror would see it. Of course, we have way too much information that the jury doesn't have, but still, I just don't feel like he was a good prosecutor. I felt he was way too offensive against the witnesses on petty things because he couldn't assail their knowledge, their data, their skill. So he used Signal. Every form of communication is encrypted. It's just Signal hasn't been breached by the police yet. So that nefariousness by using Signal to me is just, the jury is supposedly a younger jury. They know Signal is just what you use now. But if you send Snapchats, if you use Instagram, all of that is encrypted as well. So it was, I don't know, as a lawyer, did you find that he was doing a great job?
Who, Brennan? Generally speaking, throughout the trial?
Yeah.
There were a lot of things about Brennan that I liked, generally speaking. I like the structure of his opening. I didn't like the way he presented it, but I like the structure of his opening very much. I thought it was great. I really liked the way that he used the clips of Karen Reed and introduced those and used those throughout the state's case. I thought that was very effective from a repetitious standpoint. I liked how he was on direct for the most part, not as much on redirect, although I don't think it was necessarily as catastrophic initially as some people did, but it got a little tiresome towards the end. He was very dickish and off-putting sometimes, especially like on cross in ways that were off-putting. There was a lot that was very. He's also very good in attention to detail and like understanding like the minutiae of the case, because he was asking expert witnesses very sort of precise questions that required a lot of attention. Now, whether or not that's good or bad from like a ethics standpoint, or tactical standpoint, it was still notable. So there was a lot about Brennan that was worthy of emulation, but his stage presence in particular, vocal variety in particular, just that sniveling kind of, his gaslighting and the way he manipulates things was very, very off-putting at a lot of times.
I think to me that was the biggest. That's why I say he's not a good prosecutor, because again, the state has everything. The state shouldn't be petty. You watched Rittenhouse. He reminded me so much about, what's the skinny guy's name in that one? Not Lunchbox, the other one.
Binger?
He reminded me.
The prosecutor Binger?
Yeah, Binger. Yeah, he reminded me of that. I don't like when prosecutors try to play underhanded games. Of course, you can. I don't know if you have seen that case with the coroner out of South Carolina on Verdict Watch. We're going to catch up on that one. She tried to put in weapons that was tested but wasn't the red rum weapon, and the judge said, "Why?"
Exactly.
And she was, well, it's to say that SLED did look at them. Yeah, but they're not. They had nothing to do with it. Well, and I think that's weak if the prosecutor with all, and that another thing, that Hank couldn't even mention his own experts testing in the closing because he knew how bad it was. I feel that, to me, he's just underhanded, but I felt that the entire time through. So I'm not objective in this case. I have a very negative view of him because I've seen all the pre-trial hearings about, I welcome ARCA, but could you please not make them testify?
Yeah.
It would be really nice. I say bring it, but just don't bring an expert to bolster the Bowden defense. And I liked Lally better, even though he asked, what if anything, 24,000 times every day. But I like that he streamlined the case, because that third-party culprit with all these McAlberts, that was hell to go through last year. But so I like that he streamlined it, but I also think that not bringing Proctor, take the punch to the face and bring Proctor, because Proctor will be the boogeyman in the deliberation room.
Yeah.
That's just my take on it. I think as much as Karen will be burned by her own words, and remember, folks, the first thing you say to an officer who said you are under arrest is,
I want to remain silent.
A lawyer, please.
I want to remain silent.
Yeah, and if they say, hey, you want to go on TV and talk about it, you say, nah, I'll wait. Let me get a not guilty, and then I'll talk all the things you want.
Yeah, 100%.
That was, and again, these are good lawyers. She has a great team, but that was a mistake.
Yeah, I think so. I think it was a mistake.
Yeah, and a lot of people have been asking, how can he use it? Well, the Miranda says everything you say. It doesn't say everything you say in context can be used against you. It's everything you say can be used against you.
That's right. The defense could have presented more context. They have the right. But they didn't want to for whatever reason, so they didn't. So that's what the jury has.
That's what I think is one of the things I missed in the closing was and kind of an explanation to, again, take the punch. She came off bad in those video clips. She has a demeanor that will be off-putting to some jurors. And again, our system where we do so many years of deliberations and jury duty, we get used to maybe not judge the book by its cover. But jurors that is just pulled in from the seat, they will be looking at her demeanor, looking at her facial expression and say, well, she's clearly guilty because she did this, even though she might just have a bad toothache. So I think I can't understand how lawyers in that caliber ever okayed it. That's I just can't see how they could make this mistake.
I hear you.
But hey, I don't know. My chat is believing we get a verdict next week, and I think that's true. We'll probably go till Tuesday next week. But,
could do. It's a quick, it's a lot of information to get through it that quickly. It would be fast, but then again, it's Friday, and it's Friday the 13th at that. So I figure it's got to be worth something.
I said the same as one mentioned. It started on April 1st. It would be fitting if it ended on Friday the 13th. But I don't know. It's kind of like when you've been at an exam. Now we're just waiting for the result, and you're in this weird limbo state, and everything is like, because you can't argue anymore. You can't say, well, this did well, this. Everyone is on tiptoe sitting here thinking, come on, get a verdict. And for us, it's easy. Again, I've been fooling around with this case for 3 years now, since the first picture. I saw the first picture on Vices with the arm, and that's when I started looking at it. And we all know what we think. We have bias, but
I try as much as one man can to filter my bias out of it, and I'd like to think for the most part I've done a good job. Although I have to be honest, like in this last week, I was finding it really hard to like try to maintain objectivity anymore, because Brennan was like doing some really shady shit, and I was having a really tough time trying to divorce myself from it anymore. So I held on as long as I could. I'd like to think I did a decent job, but I have limits, man.
Well, I did in the first trial, because a lot of people, all the anti-Karen readers will come and say, oh, you should try and talk to this and that. And I said, I'll discuss anything on paper, everything filed in court or mentioned during pre-trial motion. I never got a call back, because they just want to say Aiden is an idiot and Karen Reed is guilty. There's never any facts. So the first trial, all of that, who did it, and it was Colin in the conservatory with a candlestick, all of that, I said, I'm not going to go into all of that. But then we kept going and going and going and going. And so, you lose your objectivity at some point, because there's so much reasonable doubt in this case. And can I just say, not that I will help anyone plan a crime, if you do this, hit his head on the electrical cabinet, claim he left the house at around 2 o'clock after Higgins went to the police station, was on camera, he had an alibi, say he left the house, went home, he was drunk as hell, and he accidentally must have had a slip and fall. Dr. Wolf confirmed this is a normal slip and fall accident. But Karen woke up too early and found him, and then all hell broke loose. That's what I got to now. I don't know who did it, I don't know, but my speculation is something happened inside the house, and it most likely was an accident, and they said, oh God, we're gonna, and then they wanted someone else to find him so they could claim that it was a slip and fall, because they wouldn't have gotten in trouble, because the coroner would have said, it looks like an accident. But I don't know. I'm speculating.
Cool. I'm interested in the space that you're in. Walk me through this space that you're in. What are these objects behind you?
This is a 1776, around that time, uh, uh, land map of Denmark. The whiteboards are every time I get a super chat, I'll make a post-it.
Okay.
This is a $5 post-it from Brandon. Brandon has his own board because he's a very generous man. This is my New Year's Eve day super chat roundup. Next to it is my grape picture painted by Jody Arias that I was gifted by a viewer once. And this is just I build a lot of Legos when I don't do trials because, hey, I'm Danish. We build Lego. So
that's where Lego's from.
It is. Started out as wooden toys and then it became plastic toys.
And what are these bottles on your cabinet behind you?
This one, it's a mixture, mostly bourbon. I like bourbon.
Respect.
There's a little port. But I tried when I turned 40. I just got out of. Well, I didn't get reelected to city council, and I thought I need a hobby. So I started buying whiskey to learn to drink it. And I don't like whiskey, but I like bourbon.
All bourbon is from the United States.
Yes, it must be. What is it?
It must be from the United States. Must be made. It must be put in new oak.
Yeah, new
barrels.
barrels.
It must be at least. It must be at least 40 proof when bottled. And there's like another one requirement too. It must be like at least there's a distilling.
There's an
distilling
age.
thing. If you're calling it straight bourbon, if straight bourbon has to be aged at least 2 years. And yeah, I'm trying to think if there's any other requirements. It must be at least 51% corn. Yeah, it must be corn grain.
But I like it for its sweetness. I don't like. I've tried Scottish and Irish, and it's too peaty.
I agree. I 100% agree. I'm a bourbon guy. I love bourbon. I've done the bourbon trail in Kentucky. I've done the whole thing. It's great. I got a T-shirt. It was fantastic.
Yeah, I should do. I just went to Tennessee last week and went to Pigeon Forge. I should have gone to the Old Smokies up there and seen that. But no, I would say I don't have the bottle now. I really like the Buffalo Trace. I know it's not a fancy
Buffalo
one,
Trace
but I like the Buffalo Trace.
Is a very good, like just standard one. Also like Wild Turkey 101 for the same reason. They're just very good standard bourbons. There's nothing wrong with them. They're just they're fantastic. I like them too.
Yeah. I gotten into rye. I have a Michter's rye and a Kentucky rye. Kentucky turkey. Is it turkey? I have some rye. I have a Gentleman Jack that was supposed to be good.
Really, you don't like Gentleman Jack? That's interesting.
I think it's not. Well, I don't like Jack D, and this should be the better. But I'm not the greatest fan of that, biggest fan of it. But I really like the Michter's rye. Is a good one if you like a little more taste to it. And I have the Michter's sour mash as well. That's different.
Okay. Yeah, Jack Daniels is technically bourbon as well, but they got a law added not that long ago, actually. I want to say like 5 years ago. It hasn't been that long, where they created a definition for Tennessee whiskey. It's actually relatively new. So for it to be Tennessee whiskey, it has to be made in Tennessee, and I believe the only technical difference is it has to be charcoal filtered, where bourbon obviously doesn't have that requirement. So Jack Daniels is charcoal filter, then Gentleman Jack is like put through a second filter, although the second filter is like only half as much as the first filter. So they put through a second charcoal filter, and that's Jack Daniels. So exciting. So if you tell Jack Daniels they're bourbon, they'll look at you funny, but it's technically correct. It does meet all the legal requirements for bourbon, so it is technically a bourbon, but they don't like to call it that.
No, because they like to be special. But no, that's a weird idea I got when I turned 40. It's parties are coming back to the courthouse.
Okay.
What? Well, someone in your chat said it, but are they?
I don't know.
Normally my mods will
usually
tell me that,
sometimes chat says some bullshit. Who knows?
Yeah, Judge's Back is one of the most because I had one time where I thought that was it was in Florida. They had, what was it? It wasn't the Laurie Schaefer case. I think it was the Ashley Benefield, the Black Swan, the ballet dancer.
Oh, yeah.
I think they said, well, we're going to stay late, but no later than 8 o'clock. And I went and went to bed because I thought, then I'm never going to reach that verdict. And I woke up to my, I have a co-host named Jamie, and she kept calling me. And I was like, what? And I don't think I made it. So, well, you can't be lucky every time. Are they coming back? I don't see anything on Twitter either.
No, but now I've got a clock on screen. That's cool.
Yeah, I love it when that stops, people are, oh, the clock stopped. It's not an official clock. It's just something Lawn and Crim puts on there. It has nothing to do with the court. Yes, it's a verdict clock. No, it's not real.
But Spinny Fan is real.
Yeah, OnlyFan is the star of the show. OnlyFan and Rescue Randy are the two stars of
Maybe
the
those
second
two
trial.
kids will get together and make it work. Who knows?
If it's just one night, it's going to be beautiful. Are they going to go to 5:30? Yeah, probably.
They already have a question. The question is, do we really have to discuss the stupid? Is that the question?
Yeah. Can we all, if we find her not guilty, can we all give Hank Brennan
punch in the face?
Yeah, just slap him.
We have some additional verdicts that weren't asked for. This has been a waste of our time. We hate you.
Imagine him losing this case. Then his two biggest cases will be losing the Karen Reed and the Whitey Bulger case.
Maybe he's the lawyer for four long causes. There's got to be somebody, right?
Yeah, I wouldn't take him on as a lawyer from now on.
Absolutely not. No. I couldn't stand his voice.
No, and he was just slimy. I don't like that. Apparently, Plevin is already saying Hank will have a chance to clean up his mistakes at trial 3.
I doubt Hank will come back for trial 3. I don't see that happening. I wouldn't. Would you?
No. I had $300,000 in my pocket. See you later. That's I'm a big grifter, but not that big a grifter that I would be on television one more time.
I'll do the prosecution.
Yeah. Yeah. At this point, do you even need a bar license? I can do it. I can do just as good a job as this guy.
Yeah.
And money, do I like wristwatches? I just have a smartwatch, but I'm a poor baker. I don't have watch money.
There's a lot of great watches that are not very expensive.
Yeah, I know, but I have a few watches, but it's just I always use my smartwatch, so the other ones is in my cupboard without batteries in it. I have a few, but mostly Danish watches, so some Fiskars and stuff like that. I'm trying to see that. I can't see anyone saying anything about anything. No, I think it was a hoax.
Could be. I'm rocking this Zen U1 homage made by a Chinese company. It actually keeps pretty good time. I really like those bold hands on that watch, so I think it looks cool.
Yeah, but I'd like it, but after I went to a smartwatch, I like that I can do all this stuff, especially when I'm in court, that I can, because sometimes our court starts at 3 a.m. Eastern because of the time difference. So if I'm running late and I can go on Discord and tell my mods that I'll be a little late to tell my chat and stuff like that. So I like that the smartwatch. I really wish, I don't know if you know the Swatch watches, really big back in the 90s. I hope they would do a smartwatch, but they haven't so far. Because I really like them. I like the G-Shock as well, but that doesn't come in a smartwatch either. So I used to use that back in the military because it was a little more durable.
Yeah, G-Shock are fantastic for that.
So, but it's a big watch to run around with every day.
It depends what G-Shock you get. I mean, some are bigger than others. The squares aren't too bad, and they're pretty lightweight, unless you get an all-steel one.
Yeah, but it's I like the big because I'm a big guy. Sure. Having a little dainty, it doesn't look good if you're a big guy. So I like the big G watch. I like the bigger watches.
Like that 50 millimeter Mudmaster or something like that.
I would love it. That should be my next grift. When I become a millionaire, I'll buy me one of those.
Okay.
Well, I'm a millionaire in American dollars, not in Danish money. That's nothing. That's no, I can't see anything about anything going on.
The only thing that's that can be a bit problematic about the G-Shocks is because they use a LCD display. If it gets really hot, sometimes the display will not work properly. So if you happen to be like, in Afghanistan in the desert running around, the display might not work, or it might black out because the watch gets too hot. So that's the only downside of the G-Shock.
Yeah, well, my days of running around in different countries paid by the Danish state is long gone. I'm too old for that crap. But no, I had it when I was deployed, and it was really good because it's just because of the light up, and it was green, so it didn't light up, so you got seen if you were out on doing things at night. So that was I really liked that watch. I still have it in the other room somewhere, but the only thing is they had that plastic on the backside to give it a little more shock absorbent, and it was too small for my wrist. But hey, that's them's the breaks.
We'll find you the right watch, my friend.
Yeah, I should talk to Branka. He's the watch guy. He's mostly into the fancy ones, but I like a little down to earth watches. Olivia Lambo on X. What is she saying? She's normally do all the good stuff. Why can't I find her now? Why doesn't she show up? There she is. Does she say anything? 5 minutes ago, she says, Karen Reed and her attorneys just returned to the courthouse. And Olivia Lambo is normally pretty well
What's so bad about
up to date.
MVMT watches? They're designed piece of shit. MVMT watches are absolute fucking garbage. That are pieces of shit fashion watches with pieces of shit movements that should die in a fire. That's the problem with MVMT watches. For whoever asked in chat, they're garbage tier. They suck ass.
Is that the ones that you need to turn all the time to keep the battery going?
No, there's other ones that it's just like
MVMT.
It's just like a cheap ass fashion watch. It's just very disposable.
Oh.
Hamilton is best value for money. Hamilton is very good value for money. Tissot makes some very good stuff in that range too.
Oh, they're boring.
Yeah.
Nothing much to them. It's not my kind.
The ones we turn
My
all the time to the
brother-in-law,
batteries.
My brother-in-law has a lot of those twisty things, so it's so weird with all the cases he has to, because you only wear one watch at the time, and when I think he has like 6 or 7 of them, so he has all these cases that constantly moves. That's a problem I don't have with my cheap watch.
I just have the one case for when I'm not wearing this and wearing my quartz instead.
Yeah, it's well, he lives in Switzerland. They have a little bit cheaper watches down there. Well, not cheaper, but the expensive watches is a little bit less expensive.
Movado. I don't really like Movado watches. I find their design very, very boring. I wouldn't buy Movado either. We're just naming bad watch brands right now, I guess, in chat's what we're doing.
A Garmin watch. I don't like Garmin. They're too big. And I don't need the GPS, so I'm not the running kind.
I'm not a fan of smartwatches in general. I don't really like smartwatches. They have to be charged all the time. I find it very annoying.
That's my biggest problem. Mine is a 2-day watch. That's way too little. And this is the big battery level. I had a Huawei before, but because of the Chinese, they don't work with the App Store, and that lasted like a week. So I like that one. So, but I'm not the biggest fan of Garmin's. But Kurt, I'm gonna jump over to my channel again because if something happens, I'll be over there and hanging out. Thank you so much for having me on.
No problem. Thanks for dropping by.
Hopefully something will happen so we don't have to spend all next week just sitting here. The Broken Baker on YouTube's.
All right, cool.
So look me up if you wanna, and hasta la taco, as
all
we
right,
say.
thanks for dropping by.
Bye.
That was fun. Hopefully he had fun. Tag Hewer. Tag has some interesting stuff. Their recent solar graph F1 is an overpriced piece of shit that I can't believe that they're trying to actually justify the cost of. But Tag and Hewer has made some interesting stuff, at least in the past. All right, let's see. Let's continue with Supreme Court stuff. All right. Let's see. Where were we on this one? Okay. In Smith versus Robinson, this court tried to harmonize the idea of specific guarantee of free appropriate public education with protections of other anti-discrimination law, ultimately concluding that IDEA's comprehensive statutory scheme was the exclusive avenue by which a disabled child or his parents could challenge the adequacy of education. Within 2 years, however, Congress enacted a new provision of IDEA overturning the prior decision of the Supreme Court, which they can do because it's statutory. There's some noise from the court now, and Spinny Fan has grown bigger in its frame. Spinny Fan is now much bigger and haunting us.
I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning ready to start up fresh. Thank you.
Okay, jury wants to go home. Jury's tired. Jury's like, we don't want to play anymore. I feel that, jury. I feel that. They're like, we'll give you to 5:30. The jury's like, no thanks. We want to go home now. So, fair enough. Fair enough. So we're all going home, and I guess we're doing jury watch on Monday. I'm not sure if we'll tune in for that. I guess we'll tune in for some of it. Is it too late for that directed verdict, Your Honor?
All right, well, I hope everyone has a good weekend with no work.
Thank you.
All right.
I feel you, jury. I feel you. I'm tired too. I am tired too. I don't blame you. Jury's like, we are out. Yeah, that's fine. We give up. We're on strike. Can juries go on strike? That'd be a good one. We're on strike till conditions improve. That'd be good. Man. Should we start a new stream and do Supreme Court stuff? We still haven't gone through this one. What should we do? I was going to keep this for jury. I guess we could wait and hold it off until, because I need something for Monday. So maybe I should just hold off and like wait till Monday and we can try with the Supreme Court again. Yeah, jury unionization. Yeah. We demand better pay. We demand better benefits. A gaming stream to decompress? Actually, a pretty decent idea. Just start a stream and do some gaming. What gaming should we do? Something that lets me turn off my brain for a while would be nice. When is that new RimWorld DLC coming out? Because that was just announced, right? When is that actually supposed to happen? Did anyone see a release date for the RimWorld DLC? About a month. In a month. Okay. The new RimWorld DLC releases in a month. Okay, exciting. What is the new RimWorld DLC anyway? Build your own grav ship and travel across the planet. Land anywhere you want to explore, hunt for treasure, scavenge for odd draft tech, and bring back souvenirs. Okay, it starts small, just a grav engine, a few rooms, some thrusters, and a tank of chem fuel to get you airborne, but over time it becomes a home. A mobile colony of bedrooms, labs, hospitals, workshop, and everything else your colony needs. Cool. To expand your ship and go further, you need to collect grav cores. You cover these glare tech devices from insect-infested caravans, alien reactors rigged with traps, crash-landed space wrecks, and orbital platforms. Cool. Odyssey is about exploration, adventure, and new ways to play. Live as nomads that move with the season and kidnap raiders by taking off while they're aboard. Embark on a 100-day journey around the world and collect every animal to build your own zoo. Design the weirdest, ugliest, most glorified, unhinged grav ship and see how far you go. Or hunker down inside an asteroid and live as long as you want in space. You can play Odyssey any way you like. Sweet. Explore new biomes and landmarks. Odyssey adds several new biomes to change how you play. In Glow Forest, bioluminescent mushrooms and psychedelic spores glow in permanent darkness. Geothermal vents belch sulfur that blocks out the sun. And normal plants can't grow here. You need to survive on fungi alone. The Scarlands are war-torn remnants of once thriving cities. Craters rupture the roads, vent, release heat and gas, and toxic rain pours constantly. Mechanoids stalk the ruins, and the only surviving animals are dangerous mutants. Sweet. The grasslands are a ranching cowpoke dream, endless fields of golden fertile land. While trees are rare here, the growing seasons are long and bountiful, and strong winds guarantee power for turbines. However, drought can strike at any time, and many forms have been lost to raging brush fires. The glacial plains feel prehistoric. Blizzards smother the land. It was snowing. Herds of mastodorms roam, and scimitar cats prowl the frozen expanse. Carved shelters in the wall of ice or seek refuge among the buried frozen ruins live as old ones did. The lava fields constantly change. Rivers of molten rock flow across the land in sudden bursts, swallowing up animals, buildings, and colonists alike. Volcanic debris crashes down from the sky, and the thick ash makes it hard to breathe. Stay safe by building barriers to divert incoming lava and wear face masks to protect your lungs. The new landmark system combines these biomes to create endless landscape variation. Landmarks have different features that can affect everything from map generation to plant variety to rare resources like obsidian. Some features even add explorable underground maps like insect mega hives. No two landmarks are alike. Carve sprawling tunnels into cliffs, chasms, crevasses, and valleys for natural defenses. Undergrounders rejoice. Settle near the ocean and build a quaint fishing town on islands, archipelagos, atolls, This sounds badass, by the way. This sounds like really fucking awesome. This sounds like some badass gaming, and I'm here for it. I want this in my life, please. I want all these things in my life. This sounds awesome. Settle near the ocean and build quaint fishing towns on islands, archipelagos, atolls, peninsulas, and forts, or construct a whole new town on water using Odyssea's new heavy bridges. Take over abandoned colonies and repurpose them for your own base. Repair walls, use the furniture, harvest gardens, and give someone else's home a second life. Raid ancient structures for resources like chem fuel, weapons, packaged meals, components, minerals, and more. I want this in my day. I want this in my life. Shut up and take my money. Shut up and take my money. I want this in my life. Survive beyond the atmosphere. Break past the atmosphere and fly into orbit with your grav ship. In space, is it a Lexus? In space, you'll land on wrecked orbital platforms, expose derelict satellites, and mine rich ores. But look out, rival space scavengers don't take kindly to competition. Sweet. Mechanoid wreck promise the most advanced gravtech and unique treasures, but murderous machines lurk among the frozen debris. Space is harsh, no oxygen, sub-zero temperatures, and a single hole breach can be lethal. Airtight walls protect your colonists and their pets from vacuums of space. Keep the power on or the oxygen pumps will shut down. Build airlocks with vac barriers to prevent depressurization and equip spacefaring colonists with vac suits before they exit into the void. Ooh. Cute, terrifying, and intelligent wildlife. Odyssey adds over 40 new animals that can be tamed, trained, traded, and eaten. You might start your game in the grasslands with a single cow that steals your crops, but as your story progresses, your grav ship could end up as an aviary filled with swans, peacocks, flamingos, and quail. Okay. Animals can be taught new skills to make them cute and useful. For example, cats and dogs can now nuzzle colonists more often to lift their mood. Predators like wolves and big cats will hunt down specific targets for you. Other pets may dig up minerals or bring back foraged snacks. Even animals that can't normally be trained, like the humble walrus, can now be upgraded using a sentience catalyst, an ultra-tech injection that enables animals to learn new tasks. So now Wally the walrus can fight your enemies. Okay, I've got a walrus. I've got a trained walrus protector. Okay, great. That's fantastic. Some species can do more than just bite and scratch. The mastodon's deafening trumpet rattles enemies and throws off their aim, while the legendary alpha thumbro roar is said to have sent attackers fleeing before the first shot is fired. You can also fish. Different fish appear in different biomes and bodies of water. Colonists can reel in meals like tuna and salmon, as well as other strange caches. Quests across the planet and beyond. You'll discover new quests through ancient maps, passing travelers, and mysterious signals. I should really be sharing this so you can see what I'm reading. That would be good. Like a competent streamer would do. Track down mythical Alphos Thumbros by following its herd across the wilderness. If you bring it down, its priceless razor-sharp horn is yours. Raid ancient mercenary crypts where the soldiers have recently awoken from cryosleep. They guard World supplies, and gang leaders own a valuable weapon that could be yours. Abandoned orbital platforms and derelict satellites drift through low orbit. They promise stockpiles of loot, but you're competing with hostile savage crews. Sometimes orbital fugitives hold up in wreckage. They are also defensive turrets, traps, and leftover mechanoids. Asteroid mines offer rich veins of plasteel, uranium, and gold, but they're vulnerable to pirates and debris from space. Get in and out and fast, and more. Ooh. A new weapon system lets you arm your colonists with special weapons they find. A sawed-off shotgun clears the room in a second. An AI-assisted rifle scope makes the worst shot accurate, and a fully golden revolver looks cool. New gear helps with new threats. Hunters, drones chase their targets and explode on contact. Wasp drones jab their prey with paralyzing needles. You can weaponize wasps. Okay. Ancient sentries patrol run down with scattergun to blast intruders. The Cyclops mechanoid barriers enemies with shield-piercing guns. And deep below, the insect hive queen stirs among chittering spawn. Nice. The machine hive mind. Far above the planet, the machine pulses with hate. The mechanoids reproduce endlessly, and they will never stop attacking until every human on the planet is dead. When you reach the inhuman mind behind the terror, you face a choice. Will you destroy it and shut down every mechanoid for good, or take control of its power? Odyssey comes with a brand new album of music. If you'd like to support Al, the cost will also be available to purchase. 1.6 is available right now on the unstable branch. The public 1.6 unstable branch should allow modders to update their mods before 1.6 is released to everyone in a month. A major part of 1.6 is performance optimization, especially for late game colonists that struggle with performance. We reworked many systems to spread out workload. The pathfinding system is now fully multi-threaded and batched, and the lighting system is also multi-threaded to make it much faster. There are lots of optimizations made to caravan foraging calculations, egg-laying pawns, alerts, hauling, animal pig calculations, as fixes to several major memory leaks. We significantly reduced game launch times. That'd be nice because the game is a little slow to launch sometimes. Note your startup times performance may differ from our test due to bottlenecks unique to your PC. Plans are more versatile than ever. Sketch out your base using 9 colors to differentiate your plan. Use blue for living quarters like rec rooms and bedrooms, orange for production. Designer tools like placing works on floors, giving orders now have different drawing styles. Caravan camps. Pitch temporary camps while traveling as a caravan. This creates a playable map for your colonists to eat, stabilize, and regroup. But don't get comfy. After a few days, enemies will close in. Camps can also be formed when a caravan will be considered lost, giving you one last shot at survival. Ooh. The caravan tent makes it a lot easier to load or unload items. And in an emergency, you can order a caravan to depart immediately. Colonists will get out of there ASAP, leaving behind unpacked items, animals, and even downed friends. This is cool. I'm in for this. I am in for this, and I want this in my life. Chicken, ducks, and geese can now fly. Okay. Scarier rework. Scarier got scarier. Infected animals now look the part, mangy red and covered in sores. Room changes. Colonists are happy with mediocre bedrooms and less upset by awful ones. Medical beds contribute less to a room being a hospital due to situations where barracks could become hospitals from a single bed. Some production buildings now get their best work done when they're in the right room, research benches and labs. This makes it more rewarding to build reasonable looking bases. I want this in my life. I want this in my life. I want this expansion in my life. Give it and let me give it to me and let me inject it straight into my veins. Okay. War Thunder is better? I'll take your word for it. RimWorld is a great game. It is a great game. Very replayable. I am in. Check Discord, I'll convince you. Okay. It's a free game to play. Well, what is it? What is War Thunder and why would I play it? Let's Google it and look it up. Realistic military vehicle online combat. Uh-huh. Why you shouldn't start playing War Thunder? It's a thing on Reddit. Inhumane amounts of grind required. Even with premium account and premium vehicle, you eventually turn into a zombie. Grinding any event vehicle takes 3-4 hours of grinding. Toxic player supported with corrupt. Toxic player base support with corrupt, not working, easily avoidable in-game systems. Uh-huh. Doesn't sound like a lot of fun. It's play to win. I'm not interested in a play to win game. I'm not interested in play to win. I don't like play to win games. That's not fun. All right, guys, I'm going to go ahead and sign off. Who's streaming and where can I dump you? Cooking streams? Not really cooking right now. Do you guys want to go to Melanie Little or do you guys want to go to Andrea? Hmm. I'll send you over to Andrea. All right, guys. I will see you soon, man. Cheers for now, my friends, and goodbye.